Hey everyone, welcome to another episode here at the Tactical Breakdown. And of course, this is a special episode here on the Instructors Roundtable. We're talking about the Kim Potter decision, the incident that took place involving Officer Kim Potter and the subsequent trial and decision that happened in that case. And so before we jump into this and before I introduce the panel, I just want to thank everybody for taking the time and being here on the podcast. You know, this is something special that we get to do with these Instructors Roundtables. That is, you're only going to really find it here. We try to find the best of the best in the world and bring them to you as subject matter experts and talk about things that are relevant right now, that are actionable and relevant to you. And so hopefully you find this conversation useful. Anything that we talk about in terms of resources or referencing, just know that after this conversation is done, I'm going to talk with these guys. We're going to get all those resources compiled, and all of that will be available linked to this on the ILET, on the free training page on the ILET website. So right attached to this recorded video, you'll be able to access it afterwards. All of those resources and references will be there for you in case you have any questions. I don't want to chew up a bunch of time going through and showing resources and references here as we talk, because it's a conversation and we're live, but those will be available for you if you need them. Also, and I don't want to speak for everybody on the panel, but I'm sure if you have any questions, comments, or concerns about the conversation we have today, if you don't want to reach out to them directly, please feel free to reach out to me or to ILET, and we will get all of those questions to the experts and get them back out to you as quickly as possible. So with that being said, the last thing I want to talk about real briefly is the ILET Network community platform that we are launching here in February. We just opened the founding members program, which we've already had a lot of people jump into, and that is kind of what spurred this idea of getting these roundtables going again, where we want to build out this core group of experts for ILET. So if you haven't checked that out already, we'll put the links in the description here in the chat and on the video afterwards. You can check out that founding members program if you want to be a part of ILET. So let's jump into this conversation. I'm going to bring the panel on and we can get the party started. All right. Gentlemen, thank you guys so much for taking the time and joining us here on this live Instructors Roundtable talking about the Kim Potter decision. For those of you who are watching this and you don't recognize the names here on the panel, they are the go-to. They are some of the top experts in the world when it comes to use of force, and especially when it comes to dealing with law enforcement. And so I'm honored to have every single one of you here. If you are a follower of ILET or their podcast, I'm sure you see a few familiar faces and some new guys that we just brought in that are amazing. And I'm so grateful for you guys and humbled that you would join us here on this show. So we're gonna go around the horn. I'm gonna let you guys introduce yourself, kind of who you are and where you're from. Keep it short and simple. Again, we're gonna link all of the bios, all of their LinkedIn accounts and everything, contacts to this afterwards. So you'll be able to find them after the show is done. So why don't we go around the horn? Vaughn, we'll start with you. You guys can do a quick introduction of yourself.
Hey, thanks for inviting us today. I'm Vaughn Kliem. I'm the director of the consulting division and executive editor of the Force Science News at the Force Science Institute. I was a police officer for about 18 years. I've been an attorney for the last 20 some odd years, and I've been a prosecutor. I was a senior attorney working for a major public safety policy writing company here in the United States, and I'm looking forward to this discussion. Thanks for having me.
Thanks, brother.
My name is Paul Taylor. I'm an assistant professor at the University of Colorado Denver School of Public Affairs. I'm a former law enforcement officer, and I currently research police decision-making, human factors, and system safety in the context of police interactions with the public.
Awesome. Thank you, Paul. Eric?
Adam, thanks for having me. Welcome, everybody. My name is Eric Daigle. I'm an attorney, the founder and principal of Daigle Law Group, LLC. Out of Connecticut, we are a consultant operational firm across the country specializing in use of force and internal affairs. Our DLG Learning Center and our Use of Force Summit is one of our major yearly events hosted on bringing a lot of these individuals who I get to spend a lot of time with together. So thanks for having me on.
Absolutely, brother. Andrew.
Well, this is a hard group to follow, but I'm attorney Andrew Branca. I'm a small town attorney in Colorado who claims a modest expertise in use of force law.
Thanks, brother. Jamie.
Hi, everybody. Jamie Borden here. Thanks for being a part of this. And Adam, thanks for having me involved. I do spend a lot of my time conducting expert review and analysis of use of force cases, most of which are high profile or controversial. And basically just trying to fight the good fight with the finite few that get to be the teller of truth. So thanks for having me on.
Absolutely. And last but definitely not least, Mike.
Thanks. Hello, everyone. Thanks for being here. My name is Mike Musengo. I'm an instructor with the Force Science Institute. So I work with Borden. Former law enforcement officer, director of a regional police academy and training commander. And right now I'm instructing courses with Force Science and Human Factors, our CERT class and our Advanced Specialist class and some other different hybrid courses. Training's my thing, and I'm just humbled to be here today with this group, hopefully to listen, learn, and maybe add a few points as well. So thanks, Adam. Appreciate it.
Absolutely. Well, I appreciate all of you being here. This is truly just a phenomenal group of, I think between all of you, I mean, I'm going to completely exclude myself from this. All of you here have been involved in thousands of cumulatively in thousands of cases when it comes to use of force and especially involving law enforcement officers. And so I think we have such a great cross section. You guys heard it here. You have experts in human factors. You have experts not only in case law, but litigation. You have training experts. And I think all of these components come into play when we talk about what happened in this incident. And to Officer Potter here, there was a lot of things that we're going to talk about today. I understand. The way I want to frame this, and just so everybody here watching, so if you're watching on YouTube, LinkedIn, you could be here on Facebook or Twitter, wherever you're watching this from. Thank you guys for being here. What we have is all of your comments are being streamed to us live on the comments thread, so we can see those come in. So if somebody has questions for the panel as we're going through our discussion, that's what we're here for. That's why this is live. So if you have questions for the panel, as long as it is doesn't include any profanity or anything like that, or isn't inappropriate, we can bring it and we'll put it out to the team, and they can do their best to answer your question for you. That's what we're here for. Obviously, there's a lot of key concepts that I'm sure we'll talk about over the first hour or so. We're planning to run this for 2 hours, but anybody who's been here before knows that's probably a pipe dream that we finish this thing right at 2 hours. But we'll do our best. And like I said, leave your comments in the chat, and if we can get to you, we will, I promise. And if we don't afterwards, please don't hesitate to reach out. And like I said, we're here to create a training resource for you. So with that being said, a lot of topics to talk about with this Kim Potter trial. The title of today's episode, Criminalizing Error, the Kim Potter decision. That's not me. That was Vaughn. Vaughn came up with the Criminalizing Error, which I thought was absolutely critical there. That was a great way to start that. And then the decision component of it, I thought of it as a double entendre. And I wanted to bring this up because what happened here, not only are we going to talk about the decision in the case, what actually happened, but we're going to talk about the decision that Officer Potter made, what led to that decision, and all of those things combined. So when we talk about this incident, I want to start, I don't know if you guys want to start from square one or if you guys want to Tarantino this shit and talk about what happened and then work it back. I don't know. It doesn't matter to me. But I do want to cover the aspects of what led to the incident occurring, what happened, actions on, and then obviously with the case. And then I want to finish talking about the repercussions of what's going to happen because of the decision that was made. We can talk about whether or not the possibility of appeal or what that looks like from the litigation perspective. But I also want to look at what does the future look like if heaven forbid this decision stands, what does that open up the law enforcement community to in the future? So not a lot of things to talk about. This should be quick. Andrew, what I'd like to do, and I know we kind of threw you under the bus, brother, and I apologize for this, but I want somebody who, I know you've gone through and on your own channel, and I know you've done reviews of this case previously. So can you just kind of give us the Coles notes of what happened in this case, and then that way we have a starting point?
Sure, happy to. I mean, I watched every minute of the trial, most of the pretrial proceedings as well, so happy to do that. Most of the facts are not really, I mean, they're not legally critical. And I should preface really all my comments tonight. I was talking to my wife earlier. I almost felt bad taking a spot on this panel, to tell you the truth, because from a purely legal perspective, the issue here is really one sentence. Now, there are thousands of other very important facets to this case, things about training and how people make decisions and how society should judge people who make mistakes and whether that should be negligent or criminal. And I just, the other panelists bear all the expertise in those topics, so I'll simply defer to them for all of that. But from a legal perspective, this is a very simple case and a very grievous miscarriage of justice, simply on the legal merits. But the basic facts were Kim Potter was a training officer, FTO, for officer under instruction. Officer Lucky, while driving around with Potter, observed Daunte Wright's car. There were some minor traffic offenses associated with the car, an expired tag, something hanging from the rearview mirror, things that Kim Potter herself testified that she probably would not have made a traffic stop on. But she was training Lucky, and you need to train people by having them go through the process. So he wanted to make the stop. She wasn't going to stop him from doing that. They made the stop, and Daunte Wright has no driver's license, no insurance, no real registration. He does apparently provide his real name. They run the name. They come back with a warrant for an arrest for a non-appearance, a bench warrant, non-appearance on a gun charge, which might lead a reasonable person to wonder if there's a gun in the car right then. Also, an order of protection taken out by a female. There was a female passenger in Daunte Wright's car, so now they're concerned that perhaps that's the female who's covered by that order of protection. They decided that Daunte Wright, given all these facts, ought to be arrested. Really, it's hard to imagine a police officer making any other decision than that an arrest was appropriate under these circumstances. They go to make the arrest, and Lucky is largely in charge of making the arrest. Again, he's under training, so Potter is a few steps or a few feet back from him, observing what he's doing, but not really herself actively engaged in the arrest. Another officer, a third officer, Sergeant Johnson, has arrived on the scene in response to a call for backup, which again is perfectly normal. He's in the passenger side of the car, and there is a female, as I said, passenger on that side of the car. Lucky gets Daunte Wright to get out of the car, stand up, unfortunately, sadly, in the open door of the car, which is probably not the best choice, but certainly nothing criminal, but a tactically poor choice. And a struggle begins to ensue when Lucky goes to handcuff Daunte Wright. Daunte Wright decides to get back in the car. He does not want to be arrested that day. He's getting in the seat of the car. The officers on scene don't know this, but he has a demonstrable reputation, history of evading arrest, fleeing from lawful arrest. He's going to do that again here today. In an effort to stop him, Officer Lucky on the driver's side and Sergeant Johnson comes in from the passenger side of the car to grab the gear shift, try to get the key out of the ignition. Lucky is struggling with him. Daunte Wright is resisting. He's trying to get the car operational. Observing all this, Kim Potter steps around from the right side of Lucky to the left side, presents a weapon she believes to be a taser. No one ever contested at any point in this trial that Kim Potter believed throughout these events that she had a taser in her hand. Nobody ever argued that she knew she had a gun in her hand, but in fact, she did not have a taser. She had her Glock pistol. She shouts, she threatens, well, cautions, I guess I should say, Daunte Wright that she's going to tase him if he doesn't comply with lawful arrest. He does not comply. She decides she will tase him. She makes the recommended challenge of taser, 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 depresses the trigger of the weapon, and fires a 9mm round into Daunte Wright with fatal effect. Is immediately horrified that she heard a loud noise instead of the taser sound, realizes she shot someone. Daunte Wright realizes he's been shot. The officers kind of step back. Daunte Wright puts the car in gear, screeches down the street like a jet, as the defense attorney would put it. but he's mortally wounded. He only makes it about a block before he crashes into another vehicle, comes to a stop. So those are the general facts of the case. The criminal charge in this case was two charges of essentially reckless manslaughter. And when you want to, we can talk about what reckless means in a legal context. There was never any evidence of recklessness in this case, which is why these convictions on these two charges of reckless manslaughter are simply a miscarriage of justice. But nevertheless, of course, the jury did choose to convict her on these charges, largely, I believe, because they were the actual law was misrepresented to the jury by the prosecution. Okay.
Whoops. There you go. Sorry about that. Thanks, brother.
No worries.
All right. So thank you, brother. That's a great recap. Obviously, I appreciate the fact that you were able to watch the entire trial. I don't know if anybody else here was able to see it kind of minute for minute.
And by the way, if I missed anything or made a mistake, feel free to correct me. I won't take it personally.
I was just going to say in the auspices of making sure that we're completely accurate and clear on this, I want to make sure that everybody on the panel here is also aware, like, if there's a discrepancy or you believe a different fact or something we want to contest something, let's do that here. Let's have that discussion here, and so that it's out in the open. So does anybody else have anything they'd like to add or change to that conversation there? No? Awesome. Okay.
Nailed it.
Fantastic.
Nice job.
Well done.
I think you're, it's interesting to me what happened in this case. Obviously I am not a lawyer. And so when all of this was happening, just like you had said, sitting there and watching this as a civilian, I'm trying to figure out how the legal system was I'm trying to figure out the legal system in this whole case. Right. And I think that's where a lot of the things, I noticed there's some people in the chats here. Bob's in the chat here. Saying he has a very different opinion than a lot of people, which is completely fine. And Bob, thank you so much for joining us, brother. I'm glad you're here. That's what these conversations are for. We're not going to sit here and Monday morning quarterback this. We're going to talk about what happened, what are the facts, but what does it actually mean moving forward? And so I want to leave this to you guys. And I'm probably going to throw Vaughn under the bus just because I know he can handle it. Vaughn, where do you think is the key point in this whole case? What is the crux of this? Where do we need to start this conversation?
Well, I want to go back to Mr. Branca for just a second, because what I've been noticing is there's a lot of police officers out there who also hold the opinion that, look, whether she meant to or not, it was a mistake and she has to be held accountable for that. I've heard that repeatedly, and so Andrew, You've made the statement it was a miscarriage, and I agree with you. You did a great job of explaining the law, and I watched all of your podcasts in regards to that. So I'd like to throw it back to you and finish that riddle. And why is it that you think this was a miscarriage? What was it about the law that convinced you that even if she didn't intend to do this, even if it was a mistake, as some of the jurors might have characterized it, why then shouldn't she be held legally accountable for that under the Minnesota law?
Sure. Well, our legal system, our society differentiates between different degrees of culpability and liability for making mistakes. There are genuine mistakes that were unforeseeable, and those carry no legal liability, not civil liability, not criminal liability. They're just mistakes. Mistakes happen in life. Then at the next level, there are mistakes where you didn't know you were making a mistake, but you should have known you were making a mistake. So you have training, you have experience, there's something about you that you should have known. And a reasonable person in your circumstance would have known that you were making a mistake. I think that accurately characterizes what happened with Kim Potter. She was a trained professional police officer for multiple decades. She clearly made a mistake. She should not have made that mistake. But that qualifies. Making a mistake that you didn't know you were making but should have known is negligence in the law. It's a basis for civil liability, not criminal liability. So when people say Kim Potter made a mistake, somebody died, she needs to be held accountable, I would agree, but she needs to be held civilly accountable, not criminally accountable, because criminal culpability requires something beyond you should have known you were making a mistake. Criminal culpability. Recklessness is a level above negligence. Recklessness is when you know you're creating an unjustified risk and you disregard that risk consciously and do it anyway. And that would require, in this case, that Kim Potter knew she had a gun in her hand that she was waving at Daunte Wright. And there was never any evidence that she knew that. Now, we could imagine a scenario in which that could have happened, right? We could imagine, say she left her taser home that day and she decided, you know what, I don't have my taser, but I'm going to pretend my pistol is a taser just to get this guy to comply with the lawful arrest. I'm going to pull my Glock. I know it's a Glock. I don't intend to fire it. I'm just trying to intimidate Daunte Wright into complying with arrest. And then the gun goes off. That would be consciously, knowingly creating a risk and consciously disregarding that risk. But that didn't happen here. There was zero evidence presented by the state or from any other source that Kim Potter consciously knew she had a gun in her hand and disregarded that risk. And therefore, her conduct cannot have been criminally reckless and cannot have been reckless manslaughter. Now, in closing argument, the prosecution made lots of claims about, well, she knew she did something wrong. You could see her conduct after the shooting. And of course she knew she did something wrong. When she heard the discharge of the pistol, she knew in the moment she had unintentionally fired her pistol. She knew she had done something wrong. That doesn't mean it was criminal. That means, arguably, it was negligent. And then on rebuttal by the state, the prosecutor, Matthews, actually told the jury that she did not have to know she had the gun in her hand in order to be guilty of reckless manslaughter. That is not the law in Minnesota or any other state in America.
And I think if you look at the motions, the pretrial motions, the state said very plainly, we do not intend to allege that she was aware she had a gun. We do not intend to allege she intentionally drew her gun. But as you pointed out, under their theory, it wasn't necessary for them to allege that to find criminal liability.
And that was a misstatement of the law that resulted in this conviction.
Right.
So I have real briefly here, I can put this up on the screen for anybody who can see this, and maybe I'll zoom in here so you guys can see better. This is an excerpt from the statute there, and I think this is going to be the crux of kind of the conversation, where it states by the person's culpable negligence. So there's the first key word there that we're going to be talking about, whereby the person creates an unreasonable risk and consciously takes chances of causing death or great bodily harm to another. And so those three key terms, the negligence that you had mentioned, Andrew, unreasonable, and then consciously takes chances. And for me, again, not being a lawyer, when you said she had to consciously, that wasn't part of the prosecution's argument.
No, there was no evidence to that.
It was the opposite. So this is where I get confused very quickly, right? So, and I think all of these components go into the human factors discussion that I know we're going to dive super deep into here, as well as those components of negligence, unreasonableness, and being conscious of her decisions. So I'll pull that down now because I don't think we need to beat that horse to death. Does anybody have any follow-up to the points that Andrew was making there?
Let me jump in on the legal side before we switch over to the human factors. And that is, I watched two very important things that came out afterwards for opinion-based. And one was an article written by Alan Dershowitz, who is a professor at Harvard Law School. And another was the interview of the jurors, or at least one juror who didn't identify themselves in the concept of just talking about their decision making. The interesting part from the legal aspect is the one thing that all lawyers here agree with is that honest mistakes are not crimes, and that's the challenge we're faced with. There could be many other issues here, whether it's prosecutorial application, whether there's a difference between elected and appointed prosecutors. The key is even the juror said the prosecutor did a great job and applied the evidence, and their analysis was a little bit where the concerning came in. But Alan used a great example there just to make your viewers understand it. Is he said, when you're talking about honest mistakes not being a crime, he said, for example, an elderly driver who accidentally puts a foot on the gas instead of the brake and runs over a child has committed, obviously killing the child. The question is, is the killing of a child a crime? And the answer would be it's not necessarily a crime, because as Andrew was pointing out, the legal application, the mens rea, the consciousness, the decision making to engage in the conduct is where did the individual have conscious decision making to engage in the high risk of serious injury or death? And the interesting part is, and Andrew kind of picked up on this, what I found very interesting watching it from the outside was that the prosecution conceded right off the bat that the officer did not intend to shoot right and that it was a mistake. So that's not an issue. We know we're dealing with a mistake. The issue is how applicable is the mistake. And what I've been using in training over the past couple of weeks is the juror that was interviewed on the news. The juror said that the turning point in deliberations came when the jurors themselves handled Potter's gun and her taser and felt the difference. The gun was twice as heavy, and the two weapons had several differences in how they were unholstered and fired. The juror actually stated and was quoted, "The taser kind of feels like a mouse click, whereas the trigger had some weight to it." And this was a turning key point for them. So I think as we bounce back and forth between the legal application, on the legal side, we're a little confused. There's two parts of confusion. First is how a mistake, if it's clearly identified as a mistake, becomes criminal. Obviously, there is civil application that is going to apply. But number two, the second part is the judge's denial of her bail in order for a pending appeal. And that was a little shocking too. So we are all definitely watching what the appellate court's going to do. And Andrew kind of touched on that, because that's very, very effective as to the appellate court's job is to ensure that the judicial process is working correctly and taking all these things into consideration. What people need to know is when you're on trial, you could have a better day than your opposing counsel. The expert that you have can do much better than the other expert. They can connect better with the jury. There's so many factors that go into a trial, which I kind of sometimes describe as a dramatized play. But when that occurs, the confusion. I mean, let's remember one thing: the jury in this situation. What did they take? They took 4 days and 27 hours. So there's a lot of conversations that are very interesting as they start to come out as to what they really focused on. And I think that's where the tires have to meet the road for us, because for trainers and policy writers and human factor experts, the purpose is how do we put that into the hands of the men and women that are working the road today?
Yeah, and what happened in this case, all this stuff about the gun and the taser being different weights and different triggers and different means of presentation, that all goes to negligence. That all goes to she should have known she had a gun in her hand.
Right.
But that doesn't amount to recklessness, which is what's required for criminal culpability. Recklessness would mean she knew she had the gun in her hand and consciously disregarded that risk. In Alan Dershowitz's example illustration with the elderly driver, if the elderly driver just mistakenly steps on the gas instead of the brake and runs over a child, that may be negligence. They should have known which pedal was which, right? Presumably. But if the elderly driver had said, you know what, this kid is taking so long to go across this crosswalk and I have errands to run and I'm going to rev my engine to give him a little bit of a scare to get him moving, and then didn't realize the car was in gear and ran him over. Well, by revving the engine, they recklessly created a risk of death. They consciously disregarded that risk. That looks like manslaughter. When you don't know you're creating the risk, you just, maybe you should have known, but you don't actually know. You're not consciously disregarding a risk. That is not a crime. That is not reckless manslaughter. That may well be civil negligence, for which you should be held civilly liable, but it's not a crime.
And I know Paul and Jamie will jump into this, but weapon confusion is nothing new. 2001, the death of Oscar Grant, the changing of the electronic control weapon from the same side to an opposite side, changing its draw mechanism. This is nothing new. Fruitville Station is a movie on that application. So this really, one of the things I believe in, and I'd love to hear from the rest of the group on this, is that when I first saw it, one of the things I said clearly is that this is a training failure. The training failure in direct relationship to under stress application of transitioning and identifying And is this a difference with the type of generational officer that we're getting? One that doesn't have as much maybe military experience or training under stress? And what are the things that we should be concerned with on the bigger scale? Here it's coming to a head, which is great to have this discussion. This is where I think the rest of you will probably have some great opinions on that.
If I can jump in real quick, because I'm going to mostly just ask questions here, because I want to hear from Paul and others. One, as I understand errors and mistakes, to be clear, mistake is the wrong intention, right? And that's a mistake. But an error is the right intention, wrong performance. And something happened in between her intent and her performance. And so then we've heard a couple of times, Andrew said she should have known. And I'm not so sure that's true when you have a human error. And so I'd like, Paul, if you'd be willing to jump on that and talk about what goes into these type of errors. And is it something you think she should have known or could have avoided?
Yeah, absolutely. And so to kind of frame this just a little bit, and there are several issues that have already come up that I want to address. But to talk about this type of error, I want to broaden it beyond just law enforcement, so that we can have an understanding of this. Because here's the thing, medicine went through a very similar kind of crisis in looking at these things. There was a study in the 1990s that looked at medical errors, and it resulted in a book, or actually a publication, called "To Err is Human." And during that process, looking at medical errors, the panel, or the investigators, found that on average there were over 90,000, closing in on 100,000 medical errors a year, where people were dying as a direct result of mistakes made by doctors or nurses in the emergency room. And one of the things that they found, and this is I think is really important to this discussion. One of the things that they found is that doctors and nurses and looking at these things, there was a very real stigma to the idea that people make mistakes, that mistakes happen in these environments. And when we look at the type of errors that occur and the follow-up to that error, it's critical to organizational learning. And a lot of high-risk occupations like medicine, aviation, oil and gas, and medicine have tried to move away from a blame-oriented culture to start to understand the system around it. And I think this is critically important when we're looking at the Kim Potter shooting. This is not the first time we've had a slip and capture type error that has resulted in weapon confusion and resulted in a death. We've had over 16 of them. And I say over 16 of them because prior to Kim Potter, we had 16 publicized cases in which officers mistook or claimed to mistake their firearm for their taser. And multiple deaths, multiple injuries in these cases. So this is not something that's new, but often, almost exclusively, our pursuit and our investigation into these incidents has been criminal in nature. We've looked at the culpability of the individual officer. In doing that, in looking at the culpability of the individual officer, we miss the systemic issues that lead to these problems. We miss potential training issues, and we'll talk about that. I don't think this is a training issue. We miss things like design issues. And I'll put it out there. Should officers be carrying on their belt a tool of any kind that if they were to manipulate their firearm in the exact same way, so if they were to do everything that they would do to discharge a taser with their firearm is going to discharge? Should officers be carrying a tool like that? Is this a design issue? One of the things that we know about research is that people, similarly situated, similarly trained people in similar situations respond in similar ways. And so where we get error, where we get a bad outcome, where we get a tragedy, we tend to get repeated tragedies across time and people. And so the fundamental question is, we've had 17 of these reported now. I'm aware of 2 additional. incidents that were never made the media. I know that there's some comments in the side box that this is the first time that we've had a weekend draw weapon confusion shooting. That's not the case. There's been another one. It just didn't happen to make the media because nobody ended up getting killed in that incident, and it didn't make the news. But we've had multiple incidents in which officers have mistaken their firearm for their taser. So how does this occur? How does it happen? What is the mechanism for this? And why do these types of things occur? Well, it's a really common phenomenon. Anybody as an officer who spent any time driving a steering column shifter, right? And whose personal POV has a center console shifter has probably experienced a very similar slip. After driving your steering column shifter over the course of a shift and getting into your personal vehicle at the end of the day and sitting down when your attention is on something else, how many of us have reached up and air shifted with that steering column shifter? Well, most of us, if that's the case, have committed or have had a slip, right? And that is the exact same type of slip that we're talking about here. The issue there is, or what's thankful there is that nothing bad happens when we make that error, right? We don't have a catastrophe when we make that error. But if you looked at that vehicle and you looked at the mechanisms inside that vehicle and you had your focus of attention there, you would say, well, it's clear that there's not a steering column shifter here, or it's clear that what you're driving right now is a center console shifter. But we make that mistake when our focus of attention is on something else. And we know that use of force incidents capture an officer's attention like nothing else. We know that officers experience things like tunnel vision and auditory exclusion during these types of incidents. And not just officers, people engaged in life and death struggles, in fights, even athletes who are engaged in sports. When their focus of attention is on something, they don't have attentional resources to give to other things. And so what we're looking at in a case like this is a design issue. If an officer doesn't have the focus of attention to give to their tools in the moment, and we know they don't. We know that officers will shoot people's hands or their weapons because their focus of attention is captured by that weapon. We know that officers experience tunnel vision, that they experience auditory exclusion. And what this means is they don't have the attentional resources to give to their tools. And so if we provide officers with tools that function in a very similar manner, and one is lethal and one is less lethal, we are going to see these types of incidents repeat. And they're going to continue to repeat until we fix the design issue. And I'm going to make one more point because I know I've talked a long time now, but one more point here. It's not a training issue. And here's the example. If we go back to the steering column shifter and we go to the central console shifter and we use that as an example, if I just trained people and they just spent a lot of time driving that center console shifter, driving that steering column shifter, and they just went back and forth. And I even had them transition, and I had them spend hours and hours and hours driving each vehicle. All I would do would be exacerbate the problem, because the issue is not them making a decision about which tool to use. The issue is that when their attentional resources are on something else, right? When their attentional resources are on what's happening, and when we're getting in a car, when our attentional resources are on going home, we don't have the attentional resources to pay to shifting, and we're going to make that mistake. And additional training with both tools will actually increase the likelihood for that type of error. And so from my perspective, it is 100% a design issue. And if we want to improve officer decision-making in those environments, we need to give them tools that don't require attentional resources for them to check whether or not they're holding a gun or a taser in their hand, and that won't discharge in the exact same way.
Yeah, along with that, I'm hoping you can talk a little bit about Dr. Wolpert's, recognition of this concept of brain gating or sensory gating, or what is brain filtering. This idea that once you are convinced that you've started the correct movement or started the correct physical movement, like throwing a punch, we stop thinking about it. We start to filter out any feedback that tells us we might be doing something wrong. So even if it's a wrong decision, if we're convinced it's the right decision, we're no longer necessarily getting that feedback or going to be aware of that feedback, like colors and weights. And I know we've talked about this at some length, but if I remember right, the idea is that, yeah, you want to overcome that by the design change such that the stimulus is salient enough that it's going to cause their attention. It's going to pull their attention back to the object rather than the performance. Is that close?
Well, and I would argue we don't want officers' attention on their tools, right? We want their attention outward on the decision-making process that's happening in front of them, right? You think about any athlete, you think about a surgeon, you think about any professional who's working, you want their attentional resources on what they're doing, on the decision-making process that's in front of them, not on the tools that they have in their hands. And so I would not design tools that draw their attention to their tools. I would design tools that allow them to function without attentional resources and won't result in error if an officer makes a mistake. Look, people are going to find themselves in bad positions. They're going to misdiagnose what's happening in front of them. They're going to misread somebody's intentions. And we should, as much as possible, have tactics, have tools, have processes that allow officers to be human beings, to make mistakes that won't result in catastrophe when they happen. And so when you're talking about sensory gating, I don't want to get into the black box of how this happens. And I think we get into a little bit of an issue about when we try to dissect how a person makes a decision. I don't know what was going through Kim Potter's mind when this occurred. What I know is that these types of errors tend to repeat themselves under similar circumstances. That doesn't mean every officer in these circumstances is going to make that type of error, but what we see is that where an error like this occurs, and we know these types of errors have to do with attentional resources, paying attention. You have something that captures your attention, and you tend to slip to a behavior that is very similar to what you've practiced before. And with firearms and Taser, very similar processes. Again, holding this very similar types tool, and the process for engaging them is exactly the same. And we know that officers do not and cannot devote attentional resources to their weapons when they're engaged in these situations. We know that officers experience tunnel vision, auditory exclusion. We know that officers tend to shoot at the weapon itself, which is not ideal. That's not even a life-saving thing for an officer, right? If an officer was shooting to save their life, they would be shooting center mass. And yet they shoot at a weapon. Why? Because they don't have the attentional resources to devote where they're even pointing their gun, right? And so if they don't have the attentional resources to even know where they're pointing their gun, why would we have a tool that if we do everything with that tool to activate a less lethal tool, it can result in a lethal outcome? And I think that's fundamentally where the problem is. The issue with pursuing this from a criminal standpoint is that's a very narrow lens. We are looking at the culpability of Kim rather than the issues in the system that actually led to the outcome. And medicine, oil and gas, aviation have moved away from that. In fact, they have legislative protection for the review so that we can learn from these incidents, so that we can improve the profession. By taking the approach of a criminal prosecution, we guarantee that the system does not improve, and we guarantee that the design does not change of that tool, and we guarantee that another officer under a similar circumstance will have the exact same issue. We guarantee it. And Sidney Decker writes, we can either blame or we can learn. We can't do both. We have to choose. And I think that's really true.
You're muted there, Eric.
You're muted. It looked really smart, though.
It was a good, smart question. Paul, on the AY and the AFI feed that was going on this, Chris Lawrence had a great point. If you remember a couple of days ago, Chief Reynolds just reminded me of this yesterday. And I want to get your thoughts on that, where he said, maybe it's time, with all of the poor litigation on the use of electronic control weapon, and you've heard me talk about the challenges with electronic control weapon, maybe it's time we start considering it to be like a shotgun, a less lethal shotgun, where you put that in the car and take it out when it's necessary. And that would be a way to handle that situation. What's your thought on his application? That now that we clearly know one thing legally, the use of electronic control weapon has been directed to certain situations that need its use, not to the everyday use that has occurred for a decade, that has caused over 900 Court of Appeals cases in this country. And so his recommendation, which I found very interesting, was maybe it's time that weapon, if we've tried to move it to the other side, we made another color, we cross-drawed it. We did all sorts of things with it, and we can't find a way to break this cycle. Maybe it's sometimes it needs to move to the car. What's your thoughts on that?
Boy, you're opening a whole can of worms, and I don't want to hog this, but here's my view on less lethal entirely. Right? We use less lethal, and when we use less lethal, it's going to change behavior, just not the way we think it's going to. And as law enforcement, it puts us into positions oftentimes where that drives lethal force encounters, taser failures, right? Beanbag shotguns. If I get another video out of LA where somebody says, watch this, and it's a beanbag shotgun deployment with somebody with a knife, we all know how that's going to end. It's going to change the behavior. The person's going to jump up and they're going to end up shooting that person, right? And that has happened over and over and over and over again. And we look at that as a solution to a problem, but we haven't looked beyond that. And we have to start looking beyond that. We have to start looking at think about this. The average taser deployment in the field, based on research, is 5 feet. The average taser deployment is 5 feet. Our officers put themselves within 5 feet of suspects that they wouldn't otherwise put themselves in front of, and that deployment is driving a bad outcome. And again, I think we need to take a holistic look at these things. We need to understand that these tactics in and of themselves, including de-escalation, right? If you're only looking at this through the lens of de-escalation, right, and you're not looking at this holistically, a de-escalation approach can actually drive a lethal encounter. If I'm approaching somebody and getting so close into the position that I need to get into in order to effectively de-escalate, how many of these times have we seen somebody put themselves too close to somebody with a knife?
So none of this is my area of expertise, right? I could imagine we could make a taser that's shaped like a beer can or a hat or a Frisbee or something other than a gun, and maybe that would help mitigate this risk. That's all. Those are all topics that are within the expertise of the broader panel. I will note, however, that it seems to me reasonable to expect that to the extent that this particular problem with Daunte Wright is perceived as being solved by Kim Potter's criminal conviction, we don't need to take any of these other steps, right? It was not a policy problem or training problem or device problem or interaction with the public problem or a non-deadly self-defense inappropriately used problem. She just committed a crime and now she's convicted and she's going to prison. So we don't have to answer any of those other questions. Those hard questions only arise if we recognize that what she did was not a crime, that it was a mistake, maybe negligence, maybe she should be held accountable on that basis. But if it was negligence, that means there were factors that contributed to that negligence that we might be able to mitigate moving forward. That conversation doesn't happen if the reason Daunte Wright is dead is because she committed a crime.
Yeah. Well, going on to Eric's question, I immediately thought, look, everything's cost, benefits, and trade-offs. What's the denominator? Meaning, how often are police officers using tasers effectively and perfectly reasonably and doing exactly what the taser is supposed to do? We need to answer that question before we start talking about removing it. The taser events I've been involved with happened with no planning. They weren't foreseeable, many of them. They were options to use to prevent having to shoot somebody. In some cases, when you need the taser, you needed the taser. So I would, as we look to answer that question of whether it's a good idea to treat it like a beanbag, shotgun, leave it in the car and bring it up, as a pre-planned, for pre-planned responses. We have to figure out what's the trade-off. When we remove that tool from the officer on the scene, what are they left with? And not to go too far down that line, but I'm already thinking of all the conversations we've had where officers are using tasers in lieu of hand-to-hand, control tactics. Same thing they were doing with pepper spray. And even as a trainer, we would have to say, look, pepper spray do not block punches. You still need to know how to close distance or get, either get in or get out. You have to know how to do that. Same thing with the taser. So it's an intermediate force option. I'd like to see how frequently it's successful.
I don't mean to get into dangerous waters here, but who was Kim Potter going to get into a fist fight with if she had pepper spray or a taser as an option? She's not getting. She's what, 5'3"? What was her height? I mean, this is and it has nothing to do with her being a woman. She's a small person dealing with large aggressors. I mean, she's not going to go hands on if she has a distance weapon. a non-deadly, she's been trained, it's non-deadly force, distance weapon like OC spray and a taser, that would be an unreasonable expectation.
So I want to jump back to Vaughn's point because he brought up numbers. I actually have numbers. Fun fact for the day. So here's just a quick overview, an overlay. So these are primary, secondary, and tactical electronic weapon uses this is since I think this is all together. But I think some of the key points here, and I just want to point out some of the numbers on the right hand side. For instance, for some reason, this conversation has happened where you'll talk to a member of the public and you'll ask them, hey, how often do you think police go hands-on with somebody? And it's like, I don't know, 25%, 1 in 5, 1 in 10. How often do you think they draw their gun? 1 in 20. How often do you think they shoot somebody? Like, whatever it is. The numbers are so far from the reality. And I think the incident here's the big number when I saw this. This incident that happened where there was a confusion of a firearm that led to a death. It's 1 per 3.14 billion contacts. That's a crazy number. So this only happens one of every 3.1 billion times an officer contacts somebody. That's a statistically substantial number. And so why is it that this narrative exists that these incidents happen and it's like the public, and I believe, I don't want to drag it back into the trial part right away, but do you think the jury's general understanding, the public's general understanding of what an officer contact looks like, and do you think that led to part of their decision-making process? If they think that officers are going hands-on much more frequently, using their tasers much more frequently, and using their firearms much more frequently, they may believe that an officer is going in there and they know this is my taser, this is my firearm. I think it came up in the case that Officer Potter had never used her taser before in her entire career prior to this moment.
26 years in uniform.
So, I mean, are we doing a disservice to officers right now by not enlightening the public? Like, hey, here's the reality of these incidents, that police are much more likely to interact with you and you have a good interaction and go home than you are to end up in some physical altercation. And I don't know how to best articulate that, but I know that you guys are going to do me justice here.
So and let me jump in here just for a second, if I can, Adam. That's a great point. And when we talk about making changes, this has happened with the baton in corrections facilities, where the appearances of a baton, an officer has used a baton justifiably in his or her intentions. The subject has moved for whatever reason, and by the Monadnock chart, has struck the individual unintentionally in a red or a yellow area, causing substantial bodily harm, and in some cases, tragically death. In some of the cases I've looked at, the baton has been removed from the jail. We've removed another tool from the officers, where very rarely is it used as an impact tool. Most often it's used as a pry tool. And without that tool, the officers are now forced to use other implementations that often look worse, and appearances are again, a video never looks good. The same thing happened with the carotid restraint. The appearances are that a carotid restraint is a chokehold. And what this all boils down to, and you made a very good point, everybody's making the same point, is that we spend our time trying to educate the public after the fact. And it's no different with this roundtable. I see some of the comments coming in, and there's some pretty staunch opinions, and I understand that. I get it, because if we're not attempting to educate, and I read every article I can get my hands on from great minds. I read, in fact, just recently, Dr. Lewinsky and Lance LaRusso put out a very short read that very, very eloquently clarifies what we're up against here with the criminalizing of human error. And this is one incident in millions. And again, we take the evidence from this particular event and start to attempt to elicit change from this event, not looking at all of the successes that we've had and the lives that have been saved with the use of a taser. And that's not to take or remove the tragedy from this event. It exists. We all know that. But to me, the efforts, spending the time I've spent in courtrooms and on the stand as an expert and trying to educate the jury in things like human factors and perception. Eric made a great point about the changes that have occurred with Taser, changing the side that's being carried on, changing the color. There's all of these things are based on the human being's ability to perceive that information without filtering it out. I saw one video where the officer was giving commands with the Taser saying, I'm drawing the yellow Taser. I'm drawing the yellow Taser. And there's a lot of bifurcated attention happening in these while he's facing off a deadly threat. That is an instance that never made the media. No one was tragically lost their lives in any way. But the problem is when an officer is faced with decisions under this kind of time compression, the weight of the Taser, the color of the Taser, none of those things matter. And it doesn't matter how much we train. If we lose that implement, as we're talking about here, if we completely lose that implement, what about the billions of lives that have been saved by the use of a lower level of force where otherwise a higher level of force would have been necessary? And again, on the legal side, I agree that there's got to be some level of culpability, and that more generally falls on the civil side. I think that the decision in this case is going to dramatically affect what happens with the use of the Taser in these situations. And I think we're going to see it hit the courts in a whole bunch of different forms. And I don't think it's going to be good.
I have to wonder, and again, I have no expertise in this, so I'll ask the rest of the panel, but I wonder, just as a normal human being, to what extent this decision would disincentivize officers from going to the Taser at all. Because they know now, if they make a mistake, they're subject to spending the rest of their life in a cage.
That's a tough question, I think. I think the big misnomer here is that for some reason, I have a feeling like the general public likes to think police officers like to draw their firearm. The majority of officers that I've ever talked to, if they could go the rest of their careers without ever having to touch their sidearm again, they would do that. If they never had to be put in those types of situations. So I think to ask that, like, that they wouldn't go to they'd want to just like, screw the Taser, I'm just going to go to my sidearm right off the hop. I don't really think that's going to happen, but I mean, I'll defer to the guys who have done it.
So I'm going to just add something on that real quick, and then I'm going to take a backseat again. When Bryan versus McPherson came out in Coronado, the use of the Taser moved, and I think this was 2011 when the decision came out. Taser, that's where the transition for the Taser became an intermediate weapon. I was responsible for implementing the training on that change, and what I saw in our department was an immediate reduction in the use of the Taser by 73%. And the reason being is because as this was taught, as Bryan versus McPherson was taught in the use of force class, everybody was saying, well, if we can't shoot a suspect that's heading back to their vehicle to get a weapon, then why even carry it? And what's happening is the result of that case law that transitioned the Taser from the very low level of just above, commands to an intermediate level of force discouraged police officers because I think they were experiencing some success with it. And then they realized that it's now a much more serious decision to use that Taser. And we all know that everybody in this panel knows that the one problem that we have as officers, most of us have been officers, is we hate the way things are, but we despise change. And that becomes an issue when we start to implement changes like this. So I think it is very possible that officers will stop using the Taser. And based on this decision, I can't say that I blame them, but we're putting ourselves in a very dangerous spot.
I would add too, as we go through, when you're on the street and you're desensitized to violence, you're used to it. You see it, you remain calm in chaos. This is not new, or ultimately it's not that big a deal to see violence. and to respond to violence. You learn very early on to put hands on other human beings and being very comfortable with it. And so when a court comes out, when a court tells me that a taser is a serious use of force, and all the cops in the room like, well, we tase each other in training and we zap each other and we've all been tased and we've used it multiple times with no injury and was highly effective. It's hard to take seriously a court who sort of shrinks back from any use of force and imagines it in a way that we don't. And so it's very hard to then adopt that perspective. It was very easy to just say, they don't understand, they don't get it. They don't understand threat assessment. They don't understand what it takes to arrest an adult human. And so I'm wondering how many officers are out there, I guess is the point, that saw this and were like, whatever, like that's ridiculous, and they're going to continue doing business. And it's sort of a play on the, rather be judged by, 12 and carried by 6 sort of mentality. But it's that idea that if the court just gets it that wrong, we're not going to adjust every single time a court gets it that wrong. So I'm curious how much of an effect or deterrent effect it's going to have.
Well, I would agree with you on one aspect, which is it is a criminal court case, and as Andrew will say, it's got a long way to go now, and now everybody's going to be watching it because it's important for the legal. When we're talking about clearly established law, and as Jamie brought up, the Bryan case, it's a Ninth Circuit Court of Appeals decision. It's something that we got to pay attention to. It's something that talks about a strong governmental interest and an intermediate use of force. And those type of words are something that legal advisors, policy writers, and trainers should all stand back and say, ooh, that's something we got to talk about. A criminal court decision. I mean, listen, every day criminal court cases occur where people are convicted or not convicted in different situations that are always going to go up to appeal. And we know this because a lot of the cases we get and we talk about in our training processes, right? All of us they came from a motion to suppress and a challenge to the underlying, and that's part of the system. And I think that's what people have to understand. And Andrew did a great job of talking about it. Is the system is not perfect. And how many times do people have to talk about the fact that the system is got its challenges and there's no way to address those challenges? It's just got to do its time. And I hope, Jamie, like you said, I hope people, and Vaughn, like you said, I hope officers take it for what it is at this point, which is one case, one decision that will see an appeal, that will see, we may be reading about a Court of Appeals case in the future on it. You never know.
One thing I'll mention too is for the general public, I mean, the lawyers know this, of course, but all these use of force police decisions that we were so familiar with, Garner, Graham, all of these folks, these are all civil cases. These are not criminal cases. Right. These are civil suits where negligence is being determined, not recklessness. The officers not being held criminally responsible for the use of force in those cases. Generally, the officer's been dismissed from the case by the time it gets to the Supreme Court because of qualified immunity. It's his department or the state who's the defendant, and the aggrieved party is seeking monetary compensation in civil suit for the harm they allege was done to usually their loved one. But they're not criminal cases where criminal liability is being determined. So when those federal cases say, no, this was wrong, this use of force was wrong, what they're doing is applying that wrong in a civil context, not in a criminal context. Right. What happened to Kim Potter was essentially what the prosecution told the jury in rebuttal after the defense had no more opportunity to speak to the jury. The prosecution told the jury that, hey, if you think this shouldn't have happened, she should have known she had a gun, that she was negligent, you can convict her of manslaughter on the basis of negligence. You don't need to look for recklessness. As long as she was negligent, that's enough for a criminal conviction. That is not the law.
Yeah, and you bring up a good point, which I think I was going to bring up tonight to see about this absurd result that could occur. If you look at qualified immunity, say this brought as a civil case, I sort of look at the standard for when does qualified immunity apply. And that is if the conduct would not have been obvious to any reasonable officer that the conduct was excessive. So if it wouldn't have been obvious that the conduct was excessive, qualified immunity applies. So imagine that standard being applied to these facts, and what is the strength of Kim Potter getting qualified immunity under these facts and yet still being convicted? It seems to be an absurd result. I think she would clearly have qualified immunity in a civil case. And I bring that up because one of the things that I noted in the case was how many officers testified that the threat she was facing would have been recognized by them, according to their training and policy, as one likely result in death and serious bodily injury.
And those officers were testifying as state witnesses, by the way.
Right. Yeah, they were. And so I think every active officer that testified, including the former chief, so I won't say he was active, but uniformed officers that testified, they would have, under their policy and in their training, perceived the threat she was facing as one of death or serious bodily injury, which would have justified the use of deadly force. So the error that she committed under that theory only elevated her to that which she could have used anyway. Now, I know, Andrew, you talked about that a little bit, that's somewhat irrelevant because we're talking about what she intended in that moment, and that's a fair point. But I just note the absurd result that could potentially have occurred if she was charged civilly or sued.
Hey, you all know we haven't let Mike speak yet, right? I mean,
Mike's muddling it up. You just wait. You haven't been on one of these before with him.
I mean, Jamie was going to come through the camera, but Mike hasn't spoken yet. So
with half an hour left, he'll literally take over the rest of the time. It'll be fantastic. You can just sit back and have a drink.
No, I think my take on this is the way my brain works as a trainer is, and a lot of what Paul said, and I agree with Paul a lot. I know we share a lot of the same books that he gives me to read, especially on human error, is what can we learn from this? Where do we go from here as a profession? As we can imagine, there's administrators and there's trainers sitting around the country watching this thinking, as administrators, well, let's put it this way. The most dangerous thing to do, I would say, is the most intuitive thing to do, and it's a coping skill. And that's to say, this won't happen here. This can't happen here. And for the individual officer, it's the same thing. The most dangerous thing to do is the most intuitive thing to do. I'm trained. I pay attention to what I do. I look at an incident like this, and I say to myself and to other people, I'd never do that. That would never happen to me. And it's one of the most dangerous things that we can do as a profession, as individuals. And I've heard this from cops that I respect, highly trained. And I think the sooner they realize that that's a coping mechanism, because we don't like to go out there and operate in this world, understanding that we really don't have that much control over that type of error when it occurs under high stress, where we're starting to kind of dance that delicate balance between automaticity, running motor skills of automaticity, and cognitive control processes. Where's my attention at? Where is it being drawn into? And what tools and skills am I executing at that time? So as far as a trainer goes, what can we learn from this going forward? Because there's what, just like a lot of these high profile cases, it's a huge issue. It's an important issue. There's two tragedies here. I look at two tragedies that occurred, the original incident and then this trial. Okay. But what do we learn from them? Because a month goes down the road, 2, 3, 4 months goes down the road, the next thing comes up, and then this kind of blows away in the wind. Back at every PD, all these agencies, what are we actually doing? We don't have the ability maybe to change Taser and the design of Taser. And I totally agree with what Paul says about the systems approach. This is, and I hear a lot of people saying, a lot of cops say, we need more training. We need better training. And where I do agree on both of those points, this is not going to make this type of issue go away. So what are the trainers and administrators left to do? There's usually a conversation between an administrator and your training commander. Hey, what's going on? How are we training this? I don't like this. This scares me. Let's do something better. And here's what typically will happen. They'll add another scenario that includes a Taser into their scenario-based training that they conduct with their in-service training once a year. That's traditionally probably what may occur for some places that are trying to, or at least think they're going to make some change or do something about it. And that's just not going to make a change in this type of incident. So mindfully crafted scenario-based training, 20% of our work time as we're out there working. Is that something we should be striving for? Absolutely. Do I think we'll ever get there? No. But every trainer is still going to have to go back and think to themselves as they're rolling around at night, not being able to go to sleep, what can I do with that 4 hours I have that day to try to make sure that this doesn't occur to my folks, to my people, and my agency? And that's something that I think is a big question to answer.
So,
but I would expect one of the
Andrew, real quick,
difficulties there
sorry,
with
brother.
this-
I'm gonna cut you off real quick there for
Sure.
a second. Just because we're right on this topic, and I know Dr. Lewinsky is in the chat here, and if I don't bring this up right now, he'll probably I'm gonna get a phone call when we're done. And just on Mike's point, and to go back to what Paul said way earlier about the error avoidance and what they've done in the aeronautic industry and the medical fields and stuff like that, utilizing like bringing in things like checklists during surgeries, pre-flight checklists and things like that. The question now comes for law enforcement is, instead of, because we know we're probably not going to get any more training time or hours, right? Does it come to the point where we start instituting like pre-event action steps, pre-event action checklists for officers as they lead into interactions with the public? And that's, I guess that's the conversation, is do we start looking at that approach that they've taken in those industries and applying them to what we're doing in law enforcement?
You have to be careful about how you take directly. I think we can learn a lot from other industries. I think it's really important that we look at how other industries or other high-risk industries are dealing with things. And Mike makes a great point. How are we going to respond to these types of incidents across the country? How did we respond to George Floyd? Well, we wrote a couple policies. There's some legislation passed. We're going to put more body cameras on officers, and we're going to do some training, and we're going to look at hiring standards. What is the focus of all those things? The focus of all those things, we're essentially looking at the human being as the liability in this issue, and we're saying if we could only control people, we wouldn't have the bad outcomes that we see. If we could just get people to do what we want them to do, we wouldn't have the bad outcomes that we see. Well, that's a problematic approach, because here's the thing. People are people, and they're going to make mistakes. They are going to, again, misdiagnose situations. They're going to get their attention captured, and we don't know when that's going to happen, right? When I teach classes with Jamie, I'll walk into the back of the class and clap my hands really loudly, and most of the class, almost all of the class, will turn their head. That wasn't them making a decision to turn their head. Their attention was captured by something, and we don't know what in our environment is going to capture our attention or when. So how can we improve decision making? How can we improve outcomes? Well, we can start to make the decision environment through tactics less complex. We can give ourselves and officers more time where possible to make decisions. Right? I've done some research, and even fractions of a second, in some cases 11/100ths of a second, can dramatically improve decision making in a simulator environment, right? So fractions of a second can improve decision making, and looking at tactics from that perspective, understanding the efficacy rates of the tools that we use, understanding that tasers have a huge failure rate, and that if we are expecting this to be effective and we're putting ourselves within less than 5 feet of somebody in order to deploy this taser under circumstances we wouldn't normally put ourselves in that situation, that's a big component of it. Looking at how long it takes to transition between tools, implementing team tactics, we've got to start to develop some resilience in our responses. And what I mean by resilience is, when an officer finds themselves in a bad situation, when an officer makes a mistake in how they've judged a situation, do they have any cushion to correct that error before it goes wrong? And again, when we have tools that are designed so similarly that they operate in exactly the same way, that gives us no resilience for that mistake, right? When we put ourselves within 5 feet of somebody to deploy a less lethal tool, expecting it to be effective, and that it's not effective, that gives us no resilience to respond. And so we need to start looking at the overall picture. And this is what we've done in medicine. This is what we've done in aviation. We aren't counting on human beings to make the correct decisions. We're counting on them to make the wrong decisions. And our tactics, our tools, our procedures give us the leeway under certain circumstances to correct our errors when they happen. And so again, police officers are not experts at use of force. This is another point I just wanted to make. They're not experts at deadly force. They're not experts at any of the tools that they train. They don't spend nearly enough time. And as Adam pointed out, it doesn't happen nearly often enough for them to be experts in this area. They are experts at other things. They're experts at de-escalating domestic violence situations, at developing probable cause, at determining whether or not somebody is being deceitful to them, at making a traffic stop and writing a ticket. They are experts at those things. That's what they get good at. That's what they do every single day. And when we see an officer that's out of position, when we see an officer that has made a mistake, it's oftentimes because they're carrying out their expertise under everyday normal circumstances. And in this case, it happens to be an officer-involved shooting. It happens to be an incident that they've never dealt with before. And so the question from my perspective is, how do we engineer some resilience into those responses so that when a human being on the street does what a human being does, makes a mistake, that it doesn't necessarily result in catastrophe for the officer or for the person that they're dealing with?
If I can jump on that real quick too, there's two things that haven't changed, right? And that is, when we look at an officer's any use of force we're looking at two main questions, right? We're looking at the threat assessment, and was that threat assessment reasonable? And then was the response to that threat reasonable or resistance reasonable? And that initial threat assessment is based on their training, education, experience, and reasonable inferences drawn therefrom. And finally, what hasn't changed is reasonable people can disagree. And that those officers, those three officers from three different perspectives at that scene, not only did they bring three different sets of training, three different sets of experiences, they're going to be drawing different inferences based on their personal experiences and the recency of those experiences. I know, Jamie, I'll springboard this over to you, because I know we just recently talked about this. What I think is getting lost in a lot of this is that reasonable people can disagree, and the law allows for that. And not only are these people not coming to the scene with the same training, education, experience, they're not experiencing the event the same way. And we have to continue to admit as an industry that has not changed. Perfection is not the standard, and there's not a single best way to evaluate a threat or respond to that threat.
Yeah, and so Vaughn, and especially, and the way I think that it attaches itself to this particular case, and I think to kind of stay on track with the Kim Potter decision, one of the questions that I had, and I was not privy to the investigation that followed this incident, but I can only guess by the outcome and by the climate that we work in that this is an incredibly politically charged environment. I know when this happened, I believe me and Dr. Taylor were together, and we just kind of looked at each other and thought, here we go, because this is the climate that we're in following the George Floyd case and all of the smaller events that took place after that became very high profile. It comes back to, for me, from my perspective, what's happening in the investigation and how did it end up where it ended up to begin with before the decision was made, it had to go to trial. And what I'm seeing is internally, myself and Dr. Taylor have the luxury of going around the country and teaching to departments, from leadership down to, top investigators and boots on the ground. And I often think all the time that I spent with Dr. Lewinsky, and that I spend talking with Vaughn, and that I converse with Dr. Taylor and Adam, and we have these conversations and this information comes up. How are we getting this information to the people that are conducting the investigations? Because what I'm seeing is a lack of understanding of these very baseline facts when we talk about human factors and the human condition involved in these critical incidents. And we've got a lot of work to do. We've got, how we're talking about the public that doesn't understand some of these things, and we have to be concerned about how the prosecution is presenting the case. Andrew talked about, and Eric both talked about how this case was won in the closing arguments as the last word, and handing a taser and handing a gun to somebody and saying, how can you possibly confuse these things? There's such a baseline misunderstanding of the human condition in these critical incidents. And as human beings, we experience these distortions day in and day out with nearly everything we do. But when it becomes the focus of one of these critical incidents, it now lacks a foundation, right? Nobody understands what a human being is experiencing in that moment. Kim Potter was not assessing the weight of that firearm when she was getting ready to use what she believed was the taser. She was filtering out. We talked about brain filtering and in the interpretation of information. That's based on what information we think is important at the time as human beings. So how do we get this information to the people that are conducting the investigations, that are making decisions, that are deciding that charges should be filed? In my opinion, this lacked all of the elements it needed to even end up in a trial.
Yes.
And so that takes me to a point where, as an expert, looking at these reports, reviewing and analyzing everything from internal affairs to the internal functionality of a force review, to the decisions that are being made at the top levels. And I've looked at some recently. These decisions are remedial. They lack such understanding. And these are from police officers. These are from upper echelon commanders that are making decisions. And I cannot for the life of me figure out how we get the education to these folks at a baseline level to where these cases don't end up in the arenas that they're ending up in, because it's literally destroying the law enforcement climate, and it's limiting our ability to hire good officers. It's limiting our ability to keep good officers. So I look at it and I bring to the table that perspective: is how did it get here in the first place, and what do we have to do? Talking about, with Mike's position as a trainer, where do we go from here? And where do we focus the training on? Is it the officer, the boot on the ground? They have to understand what they're experiencing as a human being involved in a critical incident. And oftentimes they don't. I taught for almost 9 years with the Force Science Institute, and I never taught a class. Not one time did I teach a class where I wasn't approached at or on a break or after the class by an officer who said, I finally understand why what I was carrying around as a weight for my entire career. I finally understand now why that happened. And that shouldn't be the case. We should be trying to educate folks and trying to build a knowledge base. And it's what drives me in my career choice these days. It's what drives my lectures. And our education has to be far and wide. And we have to focus on this, in my opinion. If we get the information out prior to an incident, it's an education. If we attempt to educate after the fact, it becomes an excuse or an advocation of the officer's actions. And that we have to avoid. We have to focus on the information pre-event, in my opinion.
Jamie, you and I talked about something recently. I want you to pick it up again, if you would. We often talk about slowing things down, not trying to compress time, giving ourselves discretionary time, right? Either pre-contact discretionary time or post-contact discretionary time. But you brought up something that was interesting. Kim Potter was in an FTO role, right? She was evaluating. She wasn't participating, right, initially. And if you want to talk about that, I can try to recap what we talked about. But what was the effect of that role change on the time compression with which she had to make decisions? Effectively, she went from observing to participating in a situation she may not have anticipated she needed to.
Well, and that's, again, we get into some ambiguity there, Vaughn, because none of us can put ourselves in Kim's position in that thought process. This goes back to scenarios like duty to intervene. And one of the issues that I look at in claims where there's a duty to intervene from an expert point of view is that in most cases, when an officer shows up on a critical incident, they are there to assist, not assess. So the shift in that mindset is probably very similar to someone who is gauging an officer's behavior for the purposes of filling out a form at the end of the night, where now something shifts and her involvement in that is much more critical than it started out to be. I can't help but think that that has an effect on the decision-making process. But again, we can't put ourselves in Kim's mind. But those are always factors that I think need to be considered.
There are some interesting behavioral cues with Kim that I don't think were brought up during the trial. And one of them is that she was passing the paperwork in her hand back and forth between her hands. And again, we can't speak specifically to what that means, but it's a behavioral indication about a thought process. And that thought process appears to be that she was going back and forth about what tools she should be using during this incident. As she's making those decision-making processes, which hand should I go with? Which tool should I go with? Is kind of when the fight ensued, and her attention is captured by what's happening in front of her. And these are important behavioral cues that let us know where a person's focus of attention might be during an incident. And oftentimes this type of information is missed.
Yeah, and I think with that FTO role, it's something to think about when we talk about, are we educating? What needs to change? What are we learning from this? Are we educating the field effectively? That's something, this got me thinking about, is when you are in that FTO evaluator role, you're thinking to yourself, okay, let's get going, put them in handcuffs, or do something. And if you would have already initiated the handcuffing procedures, if you would have already moved them away, if you would have already done those things, if you were the contact officer rather than the FTO, and your trainee's not doing that yet, you're seeing a compression of time. And you sort of saw this where when it goes south, now if you do want to intervene, you're playing catch up, you're behind the curve. So if there's anything to learn from that, it might be something just to imagine the FTOs being conscious. They may have to get involved sooner and not let things escalate, just to watch and see how the trainee handles that interaction. I'm not saying that's what happened here, but it certainly got me thinking about those possibilities.
Eric, I want to ask you a question real quick for you and Andrew. As many cases, and you've got a unique story because you were a police officer, you understand, you interact with police officers at every level through IA, through the legal process, through the investigative process. What is your perspective, and uniquely with your background in human factors as well, what is your perspective on these investigations and these cases? Because this isn't the only case that's ended up in a criminal arena. I've got multiple criminal cases going on right now that I don't believe should be in the criminal arena. What do you guys say? What's your perspective on the investigative process that's happening? And is there something that can be done with these investigations or with the education of department personnel to get this back on track and to get some guidance in place?
Well, just like you, I have a whole pile of criminal investigations too, which is new in the last 2 years. Prior to this, none of us as experts really had criminal work. And what I found about 2 years ago is we started getting calls from prosecutors asking to walk them through the system and help them identify. Jamie, I think you're right on the point, which is I think where the training needs to be. Yes, there is a complete failure of proper force investigation in this country. That's why we're all very busy because of that. But it's kind of like, we're not making a difference. That's for sure. We train hundreds and hundreds of people, and it's not getting better. We read a lot of terrible investigations, a lot of terrible IAs, and the thing is, if we're going to talk about the criminal aspect, the key is for me is to educate the prosecutors. And one of the things that I found about the prosecutorial system is they're kind of like the masters of their domain, and the best ones are the ones that reach out and get an expert on board and ask them. They get pushed, and that's one of the things that we've been doing in civil litigation for a long time. Is we in civil litigation we use experts all the time for the purposes of making sure that you're not missing anything. It's not, that hasn't been a common application to the criminal world, where knowledge-based individuals are giving guidance to prosecutors as to how to evaluate it. And what people need to understand is what we're really getting to here is the fact that the criminal analysis and the civil analysis, or the criminal analysis and the administrative analysis, are two very different analyses. Whether or not an officer was justified at using the level of force they've used under the criminal realm versus the application of whether there was civil liability or a violation of policy or training is two different forms of application. It really shouldn't be, but it's just because there is definitely a divide between the two entities. And with that, I also want to add something. I see a lot of people in the chat talking about it, and my litigation side started to freak out a little bit when you guys were talking about, checklists and the things that I see airplane pilots do as I'm waiting for them to fly. As a litigator, I want officers to be as prepared for their information and understanding in their processes. I do agree with Paul and Vaughn on slowing things down the best we can. But please, even as a guy who develops policies across the country, we don't need any more. To get an officer to sit there and go through a checklist like happened years ago with attempts to remove the continuum when we finally got the continuum out. These checklists really are going to challenge the decision making. And what I would put back to you, Jamie and Paul, is this: what would a checklist or another process do to the decision making in a tense, rapidly evolving, uncertain time? Because everyone's go-to in this country is, well, we need a checklist, we need another policy, we need another. And I'm looking at you going, okay, no, we don't. One, because on the lawyer side, that just means another 3 hours of deposition. Did you do this? Did you do this? Did you do this? But what I need people to understand is, because as soon as they hear a lawyer say that, they say, oh, well, you just don't want that because it will put people in bad situations. If it's going to make them better, I want them. What I want you guys to explain is why that's not going to make them better in their decision-making process.
And I'm going to, and I want to lead Paul into this because I know he was about to say something, and I don't mean to stomp on you, but I forget things quickly. One of the situations, let's just take
the gray hair problem, or is that?
Yeah, listen, I just shaved too. It's crazy. It's like the Santa Claus. When we look at use of force policies that refer to, for instance, the Graham factors, and they list in the objective standard, right? They say, okay, here's the 3-prong test. And in our policy, here's 5 to 17 additional factors that we consider to determine whether or not your use of force is within policy per the Graham standard. And that's in part of their training. And as a use of force trainer, I would train the legal standard, which is, this is how your force is going to be judged. If you are thinking about this list when you're involved in a use of force, you're probably going to be injured, or someone else is going to be injured, because there's no time for that. We have to teach the decision-making process based on reasonable behavior and knowledge and a foundation of what's happening in that interaction with another human being, understanding the human process, the human condition, the factors that exist, understanding that, and me and Paul have had this conversation a number of times, human beings don't experience distortions. They experience perceptions. We identify the distortions after the fact. They believe those things to be the facts in the moment, and we identify them as a distortion after the fact. So these officers that are out conducting business are not thinking about the Graham standards. They're thinking about the consequences of life and death with a hard forward focus on the threat facing them in the moment, which affects every aspect of the decision-making process that they're going through in that moment. We do not need another checklist for an officer to operate by, because they've never operated by a checklist from 100 years ago, from the Robert Peel days. Nobody has had a checklist where they've checked the box and said, your history, brother, I have got the go ahead. I'm about to issue an ass whooping, right? That's not the way it works, and it's never worked that way. Checklist.
Well, I'm happy when the pilot does it.
Well, absolutely.
Well, of course, the pilot's not under physical attack when he does the pre-flight check.
And that's it.
Plane, right? That's the difference. And by the way, folks, for an officer or any of us, non-police officers, to be justified in the use of deadly force against another person, there are 5 legal elements at most. That's it. There's not 50, there's not 500. So I think we need to differentiate between what's required for us to be proven guilty beyond a reasonable doubt in a criminal court in that context, which is only those 5 elements. Those are the only boxes we need to check, as opposed to what might create civil liability for us, as opposed to be what might be, if we're a cop, would we lose our job? Listen, if a department wants to put 5,000 conditions on an officer use of force, or they'll fire him if he violates any of them, all right, I guess it's up to the department. I don't care, but that ought to be at worst a loss of job liability, not 20 years in a cage liability.
Right.
Paul,
Yeah,
go
we-
ahead, and I'm gonna segue this with a check the box thing that you guys are gonna love this. So go ahead.
And to talk about checklists, I mean, when we have a process that reliably produces an outcome, checklists are fantastic, right? And we have time to do it. And the pre-flight checklist is fantastic for that. If I reliably check these things and I go through this process, I know that things will be safer. The problem is that typically law enforcement problems are not reliably solved by one specific process. Right? We have what we need in the field is creative problem solving, and checklists get in the way of creative problem solving. If I'm using a checklist in an environment which has multiple possible outcomes and for which one solution may not be the best answer, if I'm working on a checklist, it can actually inhibit decision making and prevent creative problem solving. So a pilot working on a checklist as the plane is crashing can run into real issues, because if I'm running down the checklist, I can hit the ground before I get to the end. And what I need at that point is I need a creative problem solver who understands the system that they're working in and understands solutions to those types of problems. And so when we have checklists, we can actually, and we know this, the research has shown this in other environments, if I have an environment where multiple solutions may be required to get to a good outcome, we know that checklists can actually inhibit that decision-making process and result in bad outcomes. We're really stuck in a law enforcement perspective in Taylorism during the Industrial Revolution. The organizational management approach to law enforcement is panoptic Taylorism, right? If we just watch officers closer and if we just control their behavior, or if we can control their behavior, we'll get better outcomes. That is not how decisions on how outcomes are made. And the viewpoint is a cynical viewpoint. Our viewpoint on officers is that they are a liability, and if we just control them, we'll get better outcomes. But the fact of the matter is, officers go out every day and they achieve overwhelmingly good outcomes. They are the solutions to the complex problems that we have, not the issues. And so as a profession, if we want to improve their decision environment, what we need to do is we need to get things out of their way. We need to make their decision environment less complex. We need to provide them with tools that actually work in the environments in which they're working. We need to design tactics that give them the time to see, recognize, and make good decisions. And we're not doing that currently. We're not currently focusing research in that area at all. There's probably 5 of us across the country who are actually doing solid research on police decision-making and how tools, tasks, and tactics impact outcomes. And
I mean,
imagine
it's obvious,
that,
right? Everybody
imagine that in any other profession. Imagine that in medicine, aviation, oil and gas. That would be ridiculous. All of the research in policing is focused on socioeconomic variables. And that
in
doesn't
training
improve
police
outcomes.
officers, if we imagine a scale of 1 to 10, with 10 being, I'll pretend it's a Navy SEAL, and 1 being it's me, a small town lawyer in Colorado. First of all, most departments are incentivized to train their officers for the purpose of protecting the department from civil liability, not for protecting that officer from criminal liability, individual criminal liability. The department is offering the training, providing the training, and understandably enough, they're doing it for the protection of the department, not the individual officer. And we don't train officers on a scale of 1 to 10. We're training officers to maybe a 3 or a 4. compared to a 10? Because the department decides, well, based on appellate court decisions, that's the limit of our liability. As long as we do that, it's good enough for us. Doesn't matter if it's good enough for the officer. And we don't train or pay officers at a 9 out of 10 level. We just don't do that. Society would not accept that. Society does not want that, or they would be doing it. What they want is they want to pay officers at a 2 out of 10 level and get 10 out of 10 level performance. That's not a reasonable expectation.
I'm going to jump in here.
Here's the sad truth, Andy. Not only are they not training for criminal and civil investigations, they're not training for good outcomes. They're not training to improve outcomes. And I'm making a generalization there. There are people like Mike and a few others out there.
It depends on how you define outcome, right? From the department's perspective, the relevant outcome is, do we have to pay $20 million to somebody?
Yeah.
That's their outcome. They think they're training to that outcome. They may be mistaken, but they think they're doing that. If we think as outcome as, hey, we got the arrest done and nobody got shot, that's a different outcome. That's a different measure.
I would say to the defense of a lot of, and I know we have a unique perspective, but the people who show up to our training are some of the best. And so I'm imagining all those officers out there who we know train to an incredibly high level. But your point is, it wasn't the department that trained them.
It's not the norm, and they tend to be self-selected, and they're doing that out of personal motivation. I speak at the FBI National Academy with some frequency, and those officers who show up there, they're not the norm. They are by definition exceptional officers. So of course they're different than the norm. But they're also not the guys normally out on the street making those arrests and putting cuffs on people.
Yeah, and
not at that point in their career.
To Dr. Taylor's point, one of the things John Black and I have been discussing, and I want it to become a bigger part of the conversation, it sounds like it's starting to here, is we have to recognize anyone evaluating police use of force or encounters have to evaluate the environment in which those decisions were being made. And so I've been playing around with the Kinakin framework and trying to get that sort of as part of the analysis. Are we operating in a clear environment? Is it complicated? Is it complex, or is it chaotic, or do we not even know? And when we say slow things down, give them tools so that they can create the environment, a better environment to make decisions in. And then we got to add the fact that the suspect gets a vote, right? The bad guy gets a vote, and can certainly throw our best laid plans back into complex or even chaotic. So I think it was a great point you made. I think we can't forget that. And I just wanted to add that that's an important discussion I think we should keep having.
I mean,
guys,
to a large extent, it's not the cop who decides how much force is used, right? To a large extent, it's the suspect who decides how much force is going to be used.
So Andrew killed my segue when he jumped in there originally.
Oh,
so
sorry.
now I'm gonna do it, but it's not gonna have as much impact. So thank you for that. But to Paul's point, so super interesting on that point, because as soon as you mentioned, as soon as there's an emergency on an airplane, checklist wouldn't work. If anybody's ever seen that movie Sully with Captain Sullivan, and you listen to that deposition, or even the real deposition that happened during that investigation, they literally said, "Don't you have a checklist?" And he said, "Yeah." They said, "Did you follow it?" He said, "No." And they said, "Why?" He said, "Because I had 30 years of experience telling me that it was wrong." So that, I think that is a great example of, Paul, of your point exactly, is the checklists are great, but experience for the most part will trump that almost every day of the week. Now, here was and I'll let you jump into that, but here was my original segue. We were talking about checklists. And so what I was going to say was, I think a checklist came into play during this trial at some point that actually had some impact. And that was when they were talking about Officer Potter's training, and they had asked her if she had received her Taser training within that calendar year. And she had attained her training for Taser within that year. Now, that was a check in the box training, because my understanding is that in Minnesota, Taser is done, the training is in silo. So all of that Taser training is contextualized in silo, and there was no way for her to even draw from that when an incident like this occurred. So even though she did check the box, the checklist was complete where she completed the training, we know that learning didn't actually occur in the way that we wanted it to, and that was a serious issue in this case. So, and I was going to segue that right into Mike, but like I said, now you guys killed it, so I'll pass it off to Mike anyways.
Hey, can I ask a question to the panel, actually? from someone who doesn't have any expertise in this, but it's common now for departments, if there are officers involved in especially a deadly force, use of force event, a different department is brought in to do the investigation, right? To allow for transparency and concerns of bias and so forth. I remember hearing Kim Potter testifying about her training in tasers. And one of the points she made, whether intentionally or not, was, hey, listen, when we do the scenario-based training, we know the bad guy in the scenario is my buddy. They're my friend. I've known them for 20 years. They're not actually going to hurt me. And I wonder what benefit there might be when you do scenario-based training, you do it cross-department. You bring in guys, I mean, you still don't expect they're going to hurt you, of course, but they're not the person who had donuts with you that morning. I mean, there's somebody who might be a little more physically aggressive than the guy across the desk from you might be in scenario-based training. And whether that might elevate the level or quality of the training if you were doing it with people who were not your personal friends as the aggressor bad guys.
Yeah. So Mike, and maybe also to talk about that, talking about the concept of high fidelity training when we talk about scenarios, I think would be important as well. So
yeah,
whoever wants to take that one.
Yeah, I'll jump on it, Adam, real quick, just as I was listening to Andrew again. And that's a great point. I think I'll go one step further with that. And whether it's your buddy or a complete stranger, there's complexities in role players that people that run scenario-based training understand, that the role players need to understand a great deal about scenario-based training, consistency in role play, things like that are very, very important for it to be effective. Where we traditionally find its ineffectiveness is that it's trained in what we call silo, or without integration into other skills. Now, let me give you an example of that. You show up for in-service training, maybe you have 2 or 3 days or 5 days in a row, whatever your agency does. There's a schedule that comes out. Taser training is on day 2 from 9 to noon. You know what's going on at that block of time. You've just taken away one of the most important parts about that training. Even if it is put in the right scenario, you know what's going on that day. How often are officers put in scenario-based training where we're putting on what we would call the NLTAs, non-lethal training aids? We put on all the gear, you get your SIMs, guns, or whatever, UTMs, whatever ones you use. But you know that day that you're going to get into probably a critical incident with these tools. You know it ahead of time, you know going into it, and then traditionally what would occur, and I'm not saying all departments, but this is, I would say traditionally what would occur is there's some type of checklist of performance standards that someone either gave proper commands, moved to cover, fired several rounds, got their hits, whatever, check the box. If you got most of them, the key point indicators, you got the thumbs up and you moved on, and then that was it. You went to your next training block. So you talk about how officers are trained traditionally in service training. You know what's coming, you prepare, it's already in your mind. So as far as your decision-making process, how much are we actually challenging that? What are we learning about that when we're throwing someone into a scenario when they already have an idea that, you know, within the next 20 minutes or hour, I know I'm going to be getting into a simunition force-on-force gunfight. So I'll turn myself into Vaughn for a minute. So what? Where do we go from here? So, and that is, you know, as trainers, what do we do with this? How can we make this better? How can we make scenario-based training more effective? Besides training our instructors, understanding human factors, understanding what human error is, the benefits of error in training, understanding the classifications of error. Do we even know the difference between skill, rule, and knowledge-based errors? Are we setting up scenarios where someone is probably going to step into that pothole and it's going to tell us something about their knowledge about something, or maybe the automatization of the motor skill that they're doing? That's just one part of it. The other part is, what is our instructional design? Are we bringing people in for frequent scenario-based training? And frequent, I mean bringing them in, you know, a couple of hours, a few times a week, and coming in, they're walking in and they're going through scenarios. And the high frequency scenarios are the same high frequency of the incidents that they're dealing with on the street. Knock on the door, they're dealing with a domestic or something, there's a conversation, no one gets arrested, and everybody walks away happy. Do we have scenario-based training like that? Probably not too much. You go in and you do 2 or 3 scenarios, probably 2 are critical incidents where you're going to be getting either your SIMS gun out, or you're going to have to get physical with someone, and then maybe what we would call like a cleanse the palate one, where somebody takes out a cell phone and asks you a question. Okay, so you reacted positive on that one. And that's really it. And again, I'm not just speaking for the department I came from. I think we were a bit more progressive with certain things in upstate New York. I talked to a lot of trainers from across the country when we travel, and trust me, and I'm still not slamming trainers. I am one. I'm gutting myself here. There's a lot of frustration in the amount of training time we have and their ability to go out and get training. How many trainers from agencies around where you live or that you know have the ability to go out and get training on human factors? Not only that, if they are able to get it, how many of them are trainers and know or have learned how to apply those into how you can develop training? That is a question that agencies and trainers can ask themselves. And one other point I want to make before, like Jamie said, I got my short-term memory kind of falls off, and something that Paul said. And our profession, I believe, can learn a lot from the profession of occupational safety. And I've actually learned this from my conversations with Dr. Taylor, and it turned me onto a lot of books. And when you think about industries out there, do you know of any industries, any companies that have industry where there's motor skills involved in machinery or anything that doesn't have a safety manager, a safety division that goes to safety training, safety conferences, and all of those things that companies and corporations need to try to keep their workers safe? Name one police department that has a safety manager and a safety division. No, we have a human resources division to handle our issues, human resources. So it's figure out who's the problem, fix the person. That's not it. We don't have human factors people. We have human resources people. And that's something else that I think that we can grow and improve on as a result of understanding things and the outcomes of this, not just the case, but the incident itself.
Yeah, thanks, brother. And real quick, before I throw this back to the panel, I know Jamie's got a deposition early in the morning, so I don't want to keep him waiting. So, Jamie, I'm going to let you kind of just share your thoughts here, brother, and kind of let us know what you want to leave off with.
Well, first of all, I actually have a deposition in about 8 minutes. I
thought it was the morning. Sorry, dude.
No, that's okay. But I wanted to say thanks to everybody for allowing me to be a part of this. It's humbling to be surrounded with the talent that I am surrounded with all the time. And what I want to leave with is, and just like it has been occurring here, more important to me than being exposed to the knowledge from great minds is the conversations that come from that exposure to knowledge. That's the only way we are going to turn this knowledge into wisdom. And we have a lot of work to do. Eric said it. Sometimes it feels helpless. Sometimes it feels hopeless. But there's a finite few of us that understand the things that we're dealing with. And we have to understand that more than just the public that needs this education, it's our departments internally. We've got to try to get things back on track. And it's things like this that you're doing, Adam, the classes that myself and Paul have the luxury of teaching across the country with CIR, Force Sciences classes and the studies that they're doing, the studies that Paul's doing. All of these things generate conversations that I think we need to keep going. Again, thank all of you, and thanks to everyone who has shown up. I've been reading some of the posts, and we could literally go on for 2 weeks here without a break before we covered all of this subject matter. So again, thank you. Keep the conversations going, and thanks for having me on. I'll look forward to hearing from you in the near future. Oh, and by the way, Eric Daigle is a very dear friend of mine.
All right, brother. We'll see you next week.
Are you saying that to mark the record or what?
It's on the record.
Yeah, he got you. All right. Thanks, Jamie. All right. Okay. So,
and then there were 6.
And now we're 6. But hey, look at the screen. Doesn't the screen look a lot more like it's much neater with six spaces on here?
I want that green screen that Michael has. That looks
very
awesome.
beautiful. Sorry to go back to Mike's point here. I think, Paul, I was looking at your expression there as he was talking. Did you want to follow up to what he was saying?
2 follow-ups really quick. I think Mike is making some important points, but I want to caution us about training solutions, and I want to caution us about policy solutions. All of these things come from our imagination. And I'm a trainer, right? And I think training is key. We have to have good training. And if we're going to improve officer decision making, they have to understand their tools. They have to be able to do things intuitively so that they're able to focus their attention on what's happening in front of them, and they're able to make the best decisions possible. But as trainers, we are limited by our imagination. And oftentimes, as we know, use of force encounters are rare in law enforcement. Even in really active agencies, they are rare. And we even have trainers who work in use of force who have never been involved in a high-level use of force incident. And so we are limited by the imagination of the trainers. We are limited by the imagination of the policy writer and the limitations of language in trying to craft a policy that's going to impact outcomes. And so we have to be very careful about how we do that. And we have to understand that officers involved in these incidents are facing oftentimes complexity and even chaos that we cannot account for in a training environment. They are facing things that we cannot prepare them for in a training environment. We can prepare them to understand how to use their tools. We can prepare them on some things to look for, but we can't always have them perfectly prepared to account for what they see and to do the right thing. And Adam, you brought up Sully, and this is the second point I wanted to make. What if Sully's landing on the Hudson had resulted in casualties? What if he had killed passengers by making that decision? Would we look at his decision differently? And I think this is a really important point. The decision process would have been exactly the same for Sully. But would we hold him up as a hero for the decisions that he made? And I don't think that's the case. Oftentimes when we look at a use of force encounter, we're looking at the encounter and we're saying, why did the officer do that and get involved in a shooting? Rather than saying, why did it make sense for the officer to make the decisions that he or she did in the moment? People will always make decisions that make sense to them in the moment. Always. I mean, even somebody who believes that aliens are coming down to eat their brain are going to make decisions that make sense to them in the moment. And oftentimes we take the outcome and we base our judgments on the decision making and the process that got us there on that outcome. And they're different. The same decision making process for Sully, had there been waves on the Hudson, had it been choppy on the Hudson, could have resulted in catastrophe rather than him being a hero. And so oftentimes it's variables outside of the officer's control that produce the outcomes that we see. And the same decision-making process that can result in a really good outcome in one circumstance can result in a bad outcome in another circumstance altogether.
Yeah, and to make that worse, Paul, and we saw some hints of this in the Potter case, it's not just the outcome. There was some testimony related to what the potential outcome could have been. You shouldn't even attempt a taser, because if you did, he may drive off with the taser probe still attached, and that would make him incapable of being able to drive the car. Or you would never take that shot because you could miss and hit the person behind him or hit the other officer, such that we weren't just imagining, or we weren't just looking at the outcome. We were imagining that an officer would have been unreasonable to even take the shot because of the potential outcomes that could have happened. And I laughed because I thought, so this is the case where the hostage taker has their arm wrapped around the hostage's throat. The sniper takes out the hostage taker, and someone argues it was an unreasonable shot because he could have hit the hostage. Even a successful outcome is now being scrutinized for what if it would have gone bad.
I wish I had that
no
SWAT
thing as a gunshot that has zero unintentional effect.
I wish I had
Zero,
that clip from
doesn't
Speed
exist.
queued up. You know the clip from Speed where he's like, shoot the hostage. I wish I had that I could have played it right now. That would have been perfect.
That's pure counterfactual reasoning. And we see it all the time. We do it to our own profession. We look at these cases and we say, if an officer had just done this, this never would have happened. Well, here's the fact. That will always be crystal clear in every single case.
Right.
Always.
It's just
There will
confirmation
always be an
bias.
opportunity that if an officer had turned right instead of left, a shooting wouldn't have occurred. That will always be crystal clear. And you know what we call that in the research realm? If I submitted a case study where I engaged in counterfactual reasoning, you know what would happen if I submitted that? It would be rejected outright. They would say, you're a biased investigator. You're basing this on your own judgments rather than what actually occurred in this case. And it shows a lack of understanding about why the officer made the decision that the officer did in the moment.
Yeah, and every decision, of course, officers make their response to the threat has trade-offs, right? There's risks, there's benefits, there's costs, there's trade-offs. And, you know, we started to touch on this a little earlier when we talked about, and we haven't yet mentioned recognition prime decision-making or intuitive decision-making. But what I did see and do see in a lot of these evaluation, these cases, is that we're looking at the individual facts, and there's a rational evaluation going on. The checklist, of course, is a rational stepwise evaluation of the circumstances.
And rational allows for mistakes, right? So it could be mistaken, but still reasonable.
Right.
You're police officers, none of us are required to make perfect decisions in
Right.
use of force events. We're required to make reasonable decisions, but those decisions could be imperfect, could be mistaken, as long as the imperfection or mistake is a reasonable imperfection or mistake, that is legally acceptable.
Right.
Yeah,
And I think part of the evaluation that we're having to keep pushed back is there is a post-shooting courtroom evaluation that takes place that is laid out by the Supreme Court, right? And we're going to pay careful attention to the facts and circumstances of each case as we do a balancing, a proportionality analysis, not just threat and response, but the proportionality under the Fourth Amendment of the intrusion on the individual's rights as balanced against the government interest served. And all that's great and all that's required in the courtroom after the fact. But officers involved, it is generally accepted in the law enforcement industry that officers involved in critical incidents are not going to be engaged in calm, rational, analytical thinking, right? They're engaged in more RPD, intuitive thinking. And even some of the proponents who come up against us in court and on a lot of these cases have publications that admit that fact. And yet when they analyze cases and evaluate cases, they're acting like it's a very rational, considered approach. Now, I do think that I want to make this point that I do think there has to be a rational threat assessment and response that's done, but that should be done in the training environment. Those should be the kind of calculations. The government interest should be balanced in policy. The government interest should be balanced in training. And our threat assessments and responses should be balanced in training. But when it comes to what's happening on the street, it's happening way too fast for that to be that sort of analytical process.
I just want to take a second here. I know Eric has a heart out. And so for real quickly, Eric, thanks for taking the time, brother. I know you're a super busy guy, so I appreciate you being here with us. And also, if you guys are interested in use of force training and you haven't checked out the Use of Force Summit that Daigle puts on every single year, you're going to get access to kind of everybody who's been a part of this. You see a lot of people in the chat, whether it's Blake or Lewinsky or Black or whoever, all of them are always there as well. So it's kind of the place to be. So make sure to check out that summit. And Eric, any last thoughts on this case or for anybody listening to this before you take off?
Yeah, two things. And remember, Adam, you did this because you brought up Sully to begin with, right? You did this, and then Paul took on. So I'm going to wrap it up, which is the best line out of that movie is the very clear mind. What you're looking for is human error. And so you have to make it human, right? That's the key part here. And I'm going to leave everybody with this philosophy to understand is that the Supreme Court has ruled again on June 28th on 2021 in the Lombardo case in an attempt when they kicked back an Eighth Circuit opinion, and they said and reminded the country through all the craziness that four things still matter in force analysis in determining whether an officer used excessive force. Number one, facts and circumstances matter. Number two, analyzing the relationship between the need for the use of force and the force that was used. Number three, threat assessment. And number four, active resistance. I tell everybody I see, stay forging ahead if my words can get out of my mouth. Stay on course, stay focused that the system the checks and balances of the system will work out to the point it will be necessary. So I appreciate it. I thank everybody. It's great to see all you again. Be safe, be healthy, and talk to you soon.
Just out of curiosity, Eric, was that a civil case?
That was absolutely a civil case. Yes.
Yeah. Okay. Just wondering. Thank
you.
It
always is a civil case.
Always, right? Almost invariably.
I've never seen a criminal case go to the Supreme Court on a use of force because there hasn't been any.
The federal use of force cases almost don't exist.
Yeah. Absolutely.
In the criminal context, I mean.
Right. Right. All right, everybody.
All right.
Thank you.
Thanks, man. There's quite a bit of I wonder if this, yeah, sure, we'll stick with this view here. There's been quite a few questions in the chat here, and I do want to kind of address some of them if we can. If anybody has any questions, throw them in the chat now. Sorry, this is kind of one of the ones, normally we don't get this far along before we even start addressing questions. I think you guys have been kind of doing it as we go along here, but as some questions come in, one thing I do want to get your thoughts on, and this is something that I prefaced at the beginning of this conversation, which is, what is the outcome? What is the repercussions of this decision if either one, it's appealed, or if it will be appealed, or two, if it stands, are we in for like kind of a day of reckoning in the law enforcement industry? Like, what is the repercussions of this case as a whole? And so I'll just toss that out to you guys.
You want to pick somebody to go first?
Sure, you talk first. You go first. Those are the rules, dude.
Well, I mean, in terms of just legal merit, if this is allowed to stand and used as some kind of precedent, it fundamentally changes hundreds of years of American law. These distinctions between what qualifies as negligent conduct and what qualifies as criminal conduct, these are not new concepts. These are, oh my God, adopted from Old English common law before we were even a nation. These are long-standing legal principles. So this was just an abject misrepresentation of the law to the jury for the purposes of this particular trial. I'm assuming that when an appellate court gets a hold of this, they're going to say, well, this is nonsense. We're not going to do this. And they'll reverse the conviction, send it back for a new trial. But I have to be honest, if the prosecution has to apply the actual standard for reckless manslaughter, meaning that Kim Potter knew she consciously disregarded a risk, I don't think they'll retry her, because there's zero evidence that happened. So it's kind of hard to prove guilt beyond a reasonable doubt when you have zero evidence. So I think this might be the rare case where you have a reversal, not just a reversal by the appellate courts, but then the state deciding, well, they're not going to bother to retry. Which would be their option, of course. So on just the legal merits, this ought to be reversed. If it's not reversed with prejudice, it ought to be reversed in such a way that the actual proper application of the law would be insensible.
I have a quick question as a follow-up to that, because I'm a Canadian, and I don't track your American law legal system as well as I don't track the Canadian legal system anyway. Who am I kidding? What is the timeline on this process? So as things are going right now, like, is there a standard? I understand that they have somebody has 30 days to appeal, or at least file the paperwork.
Yeah, there'll be some time limit for her to file an appeal. That's just a procedural issue. But in terms of when she would be privileged to have her appeal heard, that could be years. She could sit in prison for 5 years easily before her appeal is heard. And then, of course, that mid-level appellate court could reject her appeal, and then she would appeal to the state Supreme Court, and that could be, who knows? I mean, it's up to the courts. There's no, under American law, you have a right to a speedy trial, initially your criminal trial. So you have certain legal privileges there. But when it comes to the appellate courts, it's at their convenience.
I'll say one of the things that we started on earlier, and I think this kind of trends into it, is what does this change? We predicted a couple of years ago that with all the discussion about getting rid of qualified immunity, that they were going to do an end around, and they meaning those who were really pushing hard for police reform and accountability in ways that they believed that qualified immunity was preventing them from holding officers accountable. And we predicted they were going to start filing criminal, and of course they did, and there's been a trend towards that. And the benefit, of course,
specifically reckless criminal. Yeah. So they're trying to get to criminal charges without having to prove intent, which reckless gets by intent. You don't have to prove the person intended the harm. You just have to show that, or suggest that their conduct was somehow reckless.
Yeah. And so there's been some curious things we've been seeing in the consulting side. Well, one is they're also trying to get criminal charges by indicting officers for violating their oath, which in some states, if you violate policy, if you do anything outside of policy, If they have subjectively determined that you treated somebody inhumanely, and that's by using excessive force in their judgment, they will just file criminal charges for violation of your policy. We've seen that.
By the way, they're doing that to one of the prosecutors in the Ahmaud Arbery case. One of the prosecutors who recused herself in the Ahmaud Arbery case has now been criminally charged.
Right.
Criminally charged for not aggressively pursuing the prosecution of the McMichaels and Roddy Bryan.
Right.
Instead, recusing herself. She didn't stop the prosecution from happening. It just got deferred to other prosecutors. But that was enough for her to be a target on the radar screen.
Yeah, so some of the other curious things we've seen is, and I was a little nervous when they started setting up special prosecution offices, that they were going to take police shootings to special prosecutors. And of course, you hold your breath. Is this special prosecutor going to have a political agenda? I know some of the questions we're talking about, are we going to talk about the political side of this? And I say there's good news and bad news from my experience. The good news is for science, and I think all of these experts out here, sound like Daigle as well. We've actually been having prosecutors' offices and special prosecutors' offices getting a hold of us pre-indictment, pre-charging to help them analyze these cases. So that was an outstanding development. I was excited to see. But one of the other things was, and I don't know if they know this, but there's and I won't list who they are. We're already on their radar, but there's a progressive prosecutor's office in the United States. It's one of the bigger ones who accidentally sent us an email. It looks like that they were forwarding out to their prosecutors. Now, this is weird for me as a former prosecutor and a police officer, that they were forwarding out as opposition research that we were the ones they were going to have to contend with in these criminal cases. And so we got the email chain and we got to see that. And of course, I'm having all sorts of cognitive dissonance now because I imagined I was the good guy and I was always on the right side of justice. And now I have a prosecutor's office, including my name, in opposition research. So that was again, these are just curious developments that we're watching and now having to contend with.
So I think we really need to think of prosecutors' offices as being in one of three buckets, right? There's the well-informed prosecutors' offices that can basically do a sound legal analysis themselves. They really understand this stuff and they'll come to a legally sound conclusion. There are the poorly informed prosecutors' offices, but they know they're poorly informed and they'll seek out people like you to be better informed on particular cases. And that's awesome. That's what we should hope every prosecutor's office should do. And then there's that like 1/10 of 1% of prosecutors who don't actually care what the law is or what they should be doing. They are politically motivated. They're seeking political capital and power and advantage by bringing people to trial. And I'm afraid you cannot solve that problem through education because they're not motivated about the truth. They're motivated about what they can gain from this particular process. And there's nothing we can do about those people except whoever votes for them or however they're appointed or elected, those people would have to do something about those prosecutors. Right. But they are a tiny, tiny fraction of prosecutors. Listen, I deal with prosecutors all the time. They're largely well-intentioned public servants trying to do the right thing, protect the populace from violent criminal actors. They're awesome. I love them. Yeah, but it's a very powerful position. And unfortunately, some people have realized how relatively inexpensive it is to buy those powerful positions. And if they're bought by bad actors, then you get politically motivated prosecutorial decisions. And that's a catastrophe.
Yeah, and I might want to add one more bucket because I've called out some progressive prosecutors over the last few years, and I've gotten some direct emails back and been in some discussions with them. There's another bucket, and they're the ones who actually 100% honestly believe that cops are systemically racist, abusive, and corrupt, and it is their duty to hold them to account. And in doing so, they believe that they're actually improving community safety. They are actually seeking justice on behalf of historically disenfranchised communities. And, you know, there's a bucket of corruption and there's a bucket of these true believers who wanted to sell their case to me and help me understand that what they're doing is holding people accountable in ways that the United States has been unwilling to do historically. And that's now their calling. So I don't know what bucket they fit in, but they seem like otherwise really nice people, usually on one coast or the other. But I didn't really know what to do with them because they didn't seem highly politically motivated to me. They seemed like they were true believers.
Well,
wanting
either they're amenable to communication and cross communication, we can learn from them too, right? Or they're not. And if they're not, they're just politically motivated actors. If they're open to learning, and we're open to learning, that's only fair. Then I think you can't call them malicious. They're well-intentioned and trying to do what they think is the right thing, maybe misinformed, and we can try to inform them, and they can try to inform us.
I have a quick question on that, because with what you guys just said there, and the different types of people, I know I've found over the last, and you guys know how I work on this. I don't get into the politics or the religion or anything like that, but over the last 18 months, there's been some very strong conversations with very people that are very close to me about what's happening with COVID and all that kind of stuff. And people can be on one side or the other, but I've had very, very deep discussions where I'm on an extreme one side to their, I'm not extreme, but their one side is so far to one side that I end up being on the other side, no matter, even if I'm in the middle. They will never change their mind. I know that, but at least I can sit down and I've had long 4 or 5 hour discussions over drinks. And what I do is I try to get their side of the argument. It's kind of like debate, right? When you learn debate, what do? You try to learn your opponent's side better than they know it so that you can formulate arguments to beat them.
Yeah, I mean, that's what lawyers do as a profession. I mean,
right?
If we don't understand the other person's argument, we can hardly attack it
here's my
effectively.
question, utilizing that as context. Why are we as an industry so opposed to actually having those conversations? Because a lot of the times I see, especially the law enforcement industry, some officers are like, you just don't understand. Like they take a hard stance, and they take a hard stance one way, and it doesn't matter if somebody's willing to have a conversation with them about it. Even if they have an opposing opinion, they won't entertain that.
Well, it's
Is
because
that something that we have to start doing, is having those conversations and saying, hey, listen, we're open to having the conversation now. Like, I think by closing off and having that wall of, we know we're right, so we're just going to toe the line. I think is that causing us an issue now by taking that mindset?
people take that mindset when they don't believe the other party is acting in good faith. They believe the other party is not genuinely open to conversation and discussion.
But can't you take that? What if you went into that conversation with that assumption? So if I'm going to go, I can start a conversation with the assumption that this guy's going to try to put one over on me.
Listen, I don't tell people what to do. Do whatever you like. If you want to try to have a conversation, that's great. Nobody would be happier than me if we can come to a reasonable accommodation on all these issues.
Yeah. So
I'm not trying to say it shouldn't be done. I'm only observing as a normal human being that when people don't take that position, it's normally because they believe that the other party's not operating in good faith.
Yeah, and I'll tell you this: we do this. We go to community groups. We will go to any law school. We'll go to any campus. We talk to community groups. We do this with some regularity, and we're always looking for those opportunities. And one of the things you'll start to note is the people on the right are willing to talk to the people on the left a whole lot more than the left is willing to talk to the right, and you just have to recognize that. But I've got like a 3x5 card to remind myself that there are people who can be reached on the left. There are people who are in the anti-police camp who can be reached with facts, and we meet them. But the other thing to keep in mind when you're talking to a lot of the anti-police activists, when you think of it, if you want to think of it in terms of left and right, you have to know, are you talking to essentially Marxists who want to take down America? Well, there's no conversation to be had with those people, right? And if you're
That's my point, really.
Yeah. And the other thing is, there are populations of people, and I'm being very careful not to paint them with a broad stroke, because I want to be into these communities and these conversations where we're invited and where we can have them. But I will tell you, there are people in the population who believe that, on the right, we believe that the left have bad ideas. They are people with bad ideas. And a lot of times the people on the left look at the people on the right as bad people. And so those are very different conversations. But to your point, Adam, absolutely 100%. Get in front of as many community groups that are willing to listen to the police perspective, are willing to listen to the actual statistics. go in there with managing your expectations. You know, we all hear facts don't care about your feelings, but quite frankly, feelings don't care about your facts in many cases. And you just have to manage your expectations and reach the people who will be reached. Everyone will have that moment where something makes sense to them and clicks, whether it's a red pill moment, you know, I'll call it a blue pill moment, right? If all of a sudden they see something very clearly. And I'll use a really quick example. I had a chance to be a technical advisor on a movie out in Hollywood, and I talked to two actors during lunch. We literally sat in the grass eating lunch together, and they asked me how I could do what I did for a living, and that was educate, law enforcement. And having been police, and they knew this about me, and I said, we talked about how many unarmed Black people did the police kill last year, whatever year that was. And they both thought it was about 1,000 each year. They believed that the police shot 1,000 unarmed Black men each year. And that was the foundation of their real disdain for police. Well, they were easy. One of them, when I gave him the real facts, just looked at me and like, I knew it. I knew there was something. The other one's head about exploded. You could actually see the cognitive dissonance. They just could not get their head wrapped around how, if what I was saying was true, could they have been lied to the extent they were. So we have to meet those people where they're at. We have to manage our expectations, but having the conversation, something is going to click with some of them, and some of them, it'll never click. They have very different agendas.
I mean, it's not just actors. I speak at the FBI National Academy, and it's the FBI auditorium. Some of you have probably been there with the big thing on the wall, and it's very nice. There's 200 or 300 people, senior law enforcement from all over the country, and I'll ask them how many. And I'm invited to talk about these high-profile, politicized cases, and I'll ask them how many people believe this happened in this case, something that I know because I actually looked at the evidence, didn't happen, but the media reported 10,000 times happened. And I'll say, how many people believe X happened? And every hand will go up. And then I will show them the evidence, the uncontrovertible evidence that it didn't happen. And about maybe half of that audience, you can see on their faces, can absorb that they've been told a lie for the last 10 years. But the other half, their face turns into a piece of armor. They cannot emotionally absorb that something they believe to be true, and by the way, which they've probably themselves have told hundreds of other people. So they're emotionally invested now in that version of the narrative. They just go blank. They can't say I'm lying because I just showed them the evidence, but they also can't accept that what they believe to be true was not true. Propaganda is done because it works, folks. It convinces people of a particular narrative. None of us knows what truth is in an absolute sense, right? None of us do. We all have our biases and perspectives and views. And if you can convince people because you showed them 10,000 times on TV and blogs and whatever, but they saw it 10,000 times that X happened, they will believe that X happened, even though they weren't personally present. They don't have any personal knowledge of it. And that's their truth. That's as true to them as their personal existence. And one of the difficulties that I have with these politicized trials is when you try to pick a fair and impartial jury from people who've been brainwashed like that for a year and a half, it's impossible. That defendant cannot be given a fair trial in that environment. It's impossible.
My favorite instance of that just recently, and I don't know if Andrew, if this was something you covered or I watched it somewhere else, but it was with the Rittenhouse trial. And there was a mainstream media outlet, and I don't remember what it was, and this was during the case, and they came out and they said, he killed 3 unarmed Black men or whatever it was. And I'm sitting there and I'm like, the case is going on. They've identified the people, like we're already in, and it's a mainstream media outlet that's publishing this. And then I go, there's a big issue here. Right? There's a big issue of misinformation that's being spread, maliciously or not. Maybe somebody falls into that category of I had no idea, I'm just an idiot. But it begs the question, and I think you're seeing that more and more. And I'm wondering if this case was as a result of that, like you had mentioned.
I don't give them the benefit of the doubt anymore. These mainstream media sources, they don't get the benefit of the doubt anymore. They're
supposed to be professionals, right?
Yeah.
The journalists, the media. I mean, the
Well,
people receiving the information, you can understand how,
I'm
they're living their
supposed to be
normal
a
lives. They could be
professional. Have you seen the
deceived.
stuff that I put out?
Well,
Jeez.
Yeah.
You
Well,
must be your first time here at ILAT.
Only
Just
on
to-
your OnlyFans page, Adam.
Just to give you a microcosm of I work at a public university, right? A big public university in downtown Denver. And so I get students, undergraduate students and graduate students with all kinds of beliefs. And it doesn't help for me to stand up front and preach to them. And it doesn't help for me to bring in a law enforcement officer in uniform and have them talk to them about their experiences. That doesn't change anybody's mind. It doesn't change the officer's mind, and it doesn't change my student's mind. What I found is effective is when I bring officers in, and I'll bring 6 officers into a classroom, and I'll have them sit down in their civilian clothes with students, and we'll talk through cases. I'll put a case up on the screen. We'll go over the facts of the case, and we'll allow both the officers and the students to talk through. And at the beginning of the semester, everybody's in their camps. Everybody is sitting, with the officers are very tight-lipped. They don't want to say something that gets them in trouble with their departments. And the students are they're looking for ideological compatriots in the class, whether they're kind of right leaning or they're left leaning, whether they're Black Lives Matter advocates or they're military veterans. They kind of look for allies. By the end of the semester, after talking through these cases, after everybody gets comfortable with each other, we're all basically on the same page as we're analyzing these cases. We're all looking at the cases through the same light, and we're all coming to some of the same conclusions because we've formed a community around that, and we're having conversations, and the talk is real. It's not somebody coming in and talking down to a group of people. It's not somebody saying that they understand this situation. It's everybody allowing each other to talk. And that's really the only way that these conversations improve. And it's the only way that you start to get people where you start to see movement in people's opinions and the way they look at things. Implicit bias, right? That's been a huge topic. There's people making millions of dollars on implicit bias training. And we know based on the research, you really can't move the needle on implicit bias. We all have implicit biases. We can test them with some tests to see certain types of implicit bias under very specific circumstances. But we really can't move the needle on that with a 8-hour, 10-hour, 2-week training. We can't do it. We can move the needle on implicit bias when people are exposed to other people who inhabit that bias, when they spend time with those people. We know that watching a movie about a particular culture can change an implicit bias for a short period of time. We know that in-depth exposure to that culture can change that bias over
the melting pot.
And so I think that's important to keep in mind as we're trying to change minds and as we're trying to find middle ground on some of these topics.
You talk, there's a concept called pacing and leading that you've just hit on, right? And one of the first things with pacing and leading in the art of persuasion, right, persuading groups, is you have to find a unified identity, right? So you're able to do that in that university setting, right? You're taking the time, you're investing in them, you are getting to a point where you can at least start to recognize that everyone has each other's best interests at heart, and you can start just doing life with these communities till they trust you. And then you just start walking with them. You start pacing with them. You start educating with them. And then you can start leading. You start moving that needle. But I think what's missing often in those conversations is the amount of time it takes to get people who are diametrically opposed to build that unified identity. And I think right now with identity politics playing such a big role, and people actually taking pride in separation and pride in various identities, it's very tough right now to find that initial starting point, right? That those anthem memes, those lowest point of common agreements. But it's not to say we can't keep looking for them. So I'm glad you shared that, because I think you're in the right environment to make that happen.
There was some comments in the chat here about the different. Somebody had a question if the difference between and your thoughts on the difference of training an individual versus a train the trainer approach. But I think that kind of falls outside of a little bit of the purview of this, and I think we've done some other roundtables on that, and I think we'll definitely be doing them later on this year. So if you're interested in that type of stuff, we're gonna dive deep into those types of topics. So we're at 2.5 hours here, gents. I think we've covered a lot of components. So what I'd like to do is I'm going to go around the horn, and I'm going to give you an opportunity to say your last thoughts here as we lead out of this thing. And then I'll ask our speakers and our panelists here if you guys want to hang around for a quick AAR once we kill the live feed. And then I'll address once you guys are done here, I'll address the audience, and we'll end it there. So, Vaughn, you want to go first there, big guy?
Yeah, thanks for doing this. I think this was important. One of the impetus for this was we heard a lot of things in that trial from experts that were proposed as representing industry standards, right? Generally accepted practices, generally accepted and understood practices in law enforcement that many experts listen to, and just what that is absolutely not true. And it was not a reflection. But one of the things that strikes me is in international operational law, one of the things we look at is this thing called customary international law, which is the things that we write about, the policies. These are not statutes, they're not codified, they're customary. And so when somebody says something, if we sit back silently and we don't address it and we don't resist it, over time, it can start to sound like it is actually best practice, or it is actually generally accepted in law enforcement that whatever this expert decided to say in the Kim Potter trial is now the new standard. What was important about this conversation is we can start to identify where we disagree with some of the statements that were held out as generally accepted in law enforcement. I think we touched on a lot of them, and I still think there's more to be touched on in time. But so thank you for this. I want experts out there to have listened to this unequivocally and without any doubt know that some of the opinions held out as experts from the state absolutely did not change law enforcement. Part of it was no force would have been reasonable by Kim Potter was ridiculous. And I think all the experts who looked at that from a threat assessment or a response standpoint knew that. And so it's important to have these public forums so it's never misunderstood that this did nothing to change those generally accepted police practices. So thanks for having me. Thanks for doing this, Adam. I really appreciate it.
Absolutely. Paul.
Thank you very much for the opportunity to be here. I think the real tragedy in this case and many other cases is that when we criminalize error, we don't really have the opportunity to learn from that outcome and to improve the profession going forward. When we criminalize error, we say that the problem is the individual rather than the system that created the issue. And so we really should look at error when it does occur as a window into everyday practice. And an opportunity to learn how to improve practice going forward. And like Sidney Decker said, and I repeated it before, we can either blame or we can learn. We can't do both. We have to choose. And I think when we choose to blame and we choose to focus on the individual as the issue, we miss the opportunity to improve our system, to improve practice, and to improve outcomes going forward.
Right on, dude. Andrew.
Oh my gosh, I forgot I was here. Well, thanks for inviting me. It's been tremendous being with this panel. Paul, I didn't know you were in Denver. I'm right in Castle Rock, so I put my email in the private chat part of our group. Send me an email. It would be great to meet up for coffee and such. That would be awesome. For everyone else, I just I thank you humbly for. And I mean, I really only have one sentence to add to this entire 2.5 hour conversation. I did that. This was not reckless manslaughter as a matter of law, but I got to enjoy a great deal of expertise and insight from all the rest of you on these many other extremely vitally important issues like training and education of the public and so forth. And so I just thank you for having me on and being part of this group. It's I really appreciate it.
Absolutely, brother. Mike.
Thanks, Adam. Thanks, guys, for having me here. I was really excited to. I know I wanted to do a lot of listening, especially wanted to hear from Andrew because one person I don't know in the group, and Been watching the videos and kind of like a little bit of relief for me to be able to watch those after the trial. So thank you so much for that, Andrew. Much appreciated. Trainers and administrators out there, I just want to thank the people that are watching online here. And I know there's administrators, there's trainers out there. My heart goes out to you. And as much as a tragedy that this is, I got to keep your head up, stay positive, use this if you can, knowing, and I agree with Paul, I agree with Dr. Taylor that says that, training wasn't going to fix this. This isn't a training issue when it comes to these action errors, but administrators going to support your trainers. Can you get another day of training out of something like this? Can you look back and say, I need more time? And if you can squeeze another day out of it, even though training may not be the answer in this case, which it isn't, get that day. And administrators, please do support your trainers. Give them everything they can and support them in any way that you can, which includes some education and human factors. With that, Adam, I'll say that I've been reading through some of the comments here. There were some questions on recognition prime decision making. People wanted a little bit more info on that, and a few other questions there that I think that we could probably tag some resources to when we're done here. If you could do that, there's an article from Dr. Kliem and Kahneman, Failure to Disagree. I think that'd be a good one. Mm-hmm. And a couple other books and references that I know Dr. Taylor and I both share a passion for, that we could kind of put into that comment section down below in the chat area. For people that have resources.
Yeah, absolutely. Yeah. No, thanks, guys. And so thank you to all of our panelists here. You guys are phenomenal. Obviously, I'm humbled, like I said at the beginning of this, to have all of you be a part of this. If you just hang out for a quick AAR, and for everybody here watching, as Mike was just saying, there was a lot of things that were brought up, a lot of resources, a lot of cases and different things. I showed some charts on the screen. All of that we're going to put together. I'll put together in a nice little package for you on the ILET website. So it'll be linked under this video, so you can access all those resources, and that'll be up there. Give me about 24 hours, and I'll put all that together for you. And then if you are interested in more training like this and conversations like this, that's why we created the ILET network community. And so all of the people that you've seen here on this panel are instructors and experts as part of this community as well, and hundreds of others experts from around the world. You can join us on the ILET community platform. I hope you're able to do that. You can go to ilet.network to check that out. Links, again, will be below this video, wherever you're watching it. And a huge thank you to all of you for taking the time and spending a couple hours with us tonight to talk through this very important conversation. Obviously, I think this is kind of a hot button topic in law enforcement, and will continue to be until we figure out what the outcome of this whole thing ends up being. So thank you guys for joining us here on the roundtable. If you like these roundtables, stay tuned, because we're going to be rolling one out at the end of the month here on retention and recruitment. And then the last Thursday of every single month, we're going to be doing one on a different topic. So we're going to be releasing that information very shortly. All right. With that being said, again, thank you guys for being here. Appreciate you being a part of ILET, and we'll talk to you soon. Stay safe.